The House Judiciary Committee questioned federal officials today about the government's surveillance and data collection programs. Witnesses from the Justice Department, the FBI, and the NSA talked about the collection of phone records and the monitoring of internet traffic by federal intelligence agencies. This part of the hearing is 3 hours.
Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on oversight of the administration's use of FISA authorities, and I'll begin by recognizing myself for an opening statement. Today's hearing will examine the statutory authorities that govern certain programs operated under the Foreign Intelligence Surveillance Act, or FISA. Since the unauthorized public release of these programs, many members of Congress and their constituents have expressed concern about how these programs are operated and whether they pose a threat to American civil liberties and privacy. We have assembled 2 panels of witnesses today to help us explore these important issues. Last month, Edward Snowden, an unknown former NSA contractor and CIA employee, released classified material on top-secret NSA data collection programs. On June 5th, The Guardian released a classified order issued by the Foreign Intelligence Surveillance Court requested by the FBI to compel the ongoing production for a 3-month period of call detail records or telephony metadata. Telephony metadata includes the numbers of both parties on a call, unique identifiers, and the time and duration of all calls. On June 6th, classified information regarding a second program, the PRISM program, was reported by The Guardian and The Washington Post. News reports describe the program as allowing the NSA to obtain data from electronic service providers on customers who reside outside the United States, including email, chat, photos, videos, stored data, and file transfers. Both of these programs are operated pursuant to statutory provisions in FISA or the FISA Amendments Act. FISA was enacted to provide procedures for the domestic collection of foreign intelligence. When FISA was originally enacted in 1978, America was largely concerned with collecting intelligence from foreign nations such as the Soviet Union or terrorist groups like the FARC in Colombia. FISA set forth procedures for how the government can gather foreign intelligence inside the United States about foreign powers and their agents. The intelligence landscape has changed dramatically over the last 30 years. Today we are confronted with ongoing threats from terrorist organizations, some of which are well structured, but most of which are loosely organized, as well as threats from individuals who may subscribe to certain beliefs but do not belong to a specific terrorist group. The FISA business record provision, often referred to as Section 215 of the Patriot Act, allows the FBI to access tangible items, including business records, in foreign intelligence, international terrorism, and clandestine intelligence investigations. Unlike grand jury or administrative subpoenas in criminal investigations, which can simply be issued by a prosecutor, a FISA business records order must first be approved by a federal judge. Similar to grand jury or administrative subpoenas, a FISA business record order cannot be used to search a person's home, to acquire the content of emails, or listen to telephone calls. It can only be used to obtain third-party records. Critics of the metadata program object to its breadth, namely the ongoing collection of all customers' telephony metadata, and question whether this program conforms to Congress's intent in enacting Section 215 of the Patriot Act. I hope to hear from today's witnesses about how the collection of this metadata is relevant to a foreign intelligence or terrorism investigation, and about whether a program of this size is valuable and cost-effective in detecting and preventing terrorist plots. In the 40 years since FISA enactment, communications technologies have changed dramatically and revolutionized the transmission of international communications. The shift from wireless satellite communications to fiber optic wire communications altered the manner in which foreign communications are transmitted. The use of wire technology inside the United States to transmit a telephone call that takes place overseas had the unintended result of requiring the government to obtain an individualized FISA court order to monitor foreign communications by non-U.S. persons. Congress enacted in 2008 and reauthorized just last year the bipartisan FISA Amendments Act to update our foreign intelligence laws. the FAA permits the Attorney General and the Director of National Intelligence to target foreign persons reasonably believed to be located outside the United States to acquire foreign intelligence information. The Act requires, for the first time in U.S. history, prior court approval of all government surveillance using these authorities, including court approval of the government's targeting and minimization procedures. The PRISM program derives its authority from Section 702 of the FAA. It involves the collection of foreign intelligence information about non-U.S. persons located outside the United States. To the extent the program captures information pertaining to U.S. citizens, such interception can only be incidental, and the handling of such information is governed by court-approved minimization procedures. I look forward to hearing from our witnesses today in greater detail about how the government limits its targeting under 702 to non-U.S. persons outside the U.S., and a description of the oversight performed by the administration and the FISC of this program, including the effectiveness of the current auditing of Section 702. The terrorist threat is real and ongoing. The Boston bombing reminded us all of that. I'm confident that everyone in this room wishes that tragedy could have been prevented. We cannot prevent terrorist attacks unless we can first identify and then intercept the terrorists. However, Congress must ensure that the laws we have enacted are executed in a manner that is consistent with congressional intent and that protects both our national security and our civil liberties. We must ensure that America's intelligence gathering system has the trust of the American people. It's now my pleasure to recognize the ranking member of the full committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte, members of the committee. We on Judiciary, which is the committee of primary jurisdiction for both of the authorities we're here to discuss today, Section 215 of the Patriot Act and Section 702 of the FISA Amendments Act. Over the past decade, the members of this committee have vigorously debated the proper balance between our safety and our constitutional right to privacy. And so I join in welcoming the two panels, for each very fairly made up, to this discussion today. I think it's an important one. But we never at any point during this debate have approved the type of unchecked, sweeping surveillance of United States citizens employed by our government in the name of fighting the war on terrorism. Section 215 authorizes the government to obtain certain business records only if it can show to the FISA court that the records are relevant to an ongoing national security investigation. Now, what we think we have here is a situation in which if the government cannot provide a clear public explanation for how its program is consistent with the statute, then it must stop collecting this information immediately. And so this metadata problem, to me, has gotten quite far out of hand, even given the seriousness of the problems that surrounded and created its need. Now, I have another concern that pertains to the administration's track record of responding to the criticisms of these programs. We know Director Clapper's misstatements and others. National Security Agency Director General Keith Alexander had to make retractions. Even FBI Director Robert Mueller is not empowered to rewrite history. But what we have is our conversation, which requires focusing on improving both more public scrutiny and congressional oversight of these programs. Over the last weeks, the administration has asserted that its conduct of this surveillance with congressional support, because they've briefed some members of these programs in the past. But that is not sufficient, since we're in a catch-22 situation in a classified briefing in a secure setting, and we cannot discuss it publicly, certainly not even with our constituents. But if we skip the briefing, we risk being uninformed and unprepared. One simple solution to this problem would be to publicly release significant FISA court opinions, or at the very least, unclassified summaries of these opinions. This solution would have the added benefit of subjecting the government's legal claims to much-needed public scrutiny. And over the past decade, the court has developed a body of law that instructs the government about what it may do with the information it collects. There's no legitimate reason to keep this legal analysis from public interest any longer. And if we are to strike the right balance with these surveillance authorities, which I think is an important purpose of the hearing today, then we must bring the public into the conversation as soon as it's appropriate and without delay. And I am not talking about releasing any classified information. Instead, I'm simply asking our constituents to trust us, as I am asking you and the executive branch to trust them. And the need for more declassification, I think, is very dominant, in my opinion, as to how we should move this today. And I thank the chair.
I thank the ranking member for his comments, and would say in regard, I share his concern about some classified information that does not need to be classified. I also would say that because of the nature of the questions that we would like to ask, some of which cannot be asked or answered here in an open hearing, we will definitely be planning a second hearing on this subject where we can ask those questions in a classified setting to again assure ourselves of the answers that we need. Before we begin with questions for our witnesses, I must stress that first of all, without objection, all other members' opening statements will be made a part of the record. Before we begin with questions for our witnesses, I must stress that the programs this hearing is addressing remain classified. I expect the witnesses appearing before us today, particularly on our first panel, to answer questions from members with as much candor as possible given the unclassified setting. But I also wish to caution members of the committee that they should be cognizant of this unique dynamic when phrasing their questions. The simple fact that certain programs have been leaked does not mean that they have been declassified, and members and witnesses alike would be violating the law were they to disclose classified information during this hearing. I would also like to note that the committee intends to hold a subsequent classified briefing for members so that we have an opportunity to more closely examine those programs and pose questions to our witnesses that are not appropriate in this open setting. We welcome our first panel today, and if you would all please rise, we will begin by swearing in the witnesses. Do you and each of you swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you very much. Let the record reflect that all of the witnesses responded in the affirmative, and we'll now proceed to introduce our witnesses. Our first witness is Mr. James Cole, the Deputy Attorney General of the United States at the Department of Justice. Mr. Cole first joined the agency in 1979 as part of the Attorney General's Honors Program and served the department for 13 years as a trial lawyer in the Criminal Division. He entered private practice in 1992 and was a partner at Bryan Cave LLP from 1995 to 2010, specializing in white-collar defense. Mr. Cole has also served as chair of the American Bar Association White-Collar Crime Committee and as chair-elect of the ABA Criminal Justice Section. Mr. Cole received his bachelor's degree from the University of Colorado and his Juris Doctor from the University of California at Hastings. We are fortunate to have him and his expertise with us today. Our second witness is Mr. Robert S. Litt, the second General Counsel of the Office of the Director of National Intelligence. Previously, Mr. Litt was a partner at Arnold & Porter, LLP, and served as a member of the Advisory Committee to the Standing Committee on Law and National Security at the American Bar Association. From 1994 to 1999, he served as Deputy Attorney General at the U.S. Department of Justice, where he worked on issues of national security, including FISA applications. He began his legal career as a clerk for Judge Edward Weinfeld of the Southern District of New York and Justice Potter Stewart of the United States Supreme Court. Mr. Litt earned his bachelor's degree from Harvard University and his law degree from Yale. We welcome his experience and expertise. The third member of our first witness panel is Mr. John C. Inglis, the Deputy Director and Senior Civilian Leader of the National Security Agency, acting as the agency's Chief of Operations. Mr. Inglis began his career at NSA as a computer scientist within the National Computer Security Center. Promoted to NSA's Senior Executive Service in 1997, he subsequently served in a variety of senior leadership assignments and twice served away from NSA headquarters, first as a visiting professor of computer science at the United States Military Academy and later as the U.S. Special Liaison to the United Kingdom. Mr. Inglis is a graduate of the United States Air Force Academy, subsequently completing 9 years of active service and 21 years as a member of the Air National Guard. He holds advanced degrees in engineering and computer science from Columbia University, Johns Hopkins University, and the George Washington University, and we thank him for joining us and sharing his expertise as well. And finally, on the first panel, Ms. Stephanie Douglas, Executive Assistant Director of National Security Branch of the Federal Bureau of Investigations. Ms. Douglas began as a special agent with the FBI in November 1989. She first reported to the Washington Field Office, where she worked violent crime, public corruption, and national security matters. Before returning to the FBI headquarters in 2007, she served as an FBI detailee to the CIA's Counterintelligence Center, as well as supervisory special agent for a counterintelligence squad at the Washington Field Office, directing sensitive national security investigations. Before assuming her current post, Ms. Douglas was special agent in charge of the San Francisco Division. Ms. Douglas earned her bachelor's degree in history at the University of Tennessee, and we are pleased to have her share her expertise with us today as well. We thank all of you for joining us, and we will turn first to Mr. Cole for his testimony.
Thank you, Mr. Chairman, Mr. Ranking Member, and members of the committee for inviting us here to speak about the 215 Business Records Program and Section 702 of FISA. With these programs and other intelligence activities, we are constantly seeking to achieve the right balance between the protection of national security and the protection of privacy and civil liberties. We believe these two programs have achieved the right balance. First of all, both programs are conducted under laws passed by Congress. Neither is a program that has been hidden away or off the books. In fact, all three branches of government play a significant role in the oversight of these programs. The judiciary, through the Foreign Intelligence Surveillance Court, plays a role in authorizing the programs and overseeing compliance. The executive branch conducts extensive internal reviews to ensure compliance, and Congress passes the laws and oversees our implementation of those laws and determines whether or not the current laws should be reauthorized and in what form. I'd like to explain in more detail how this works with respect to each of the two programs. The 215 program, as many of you have already heard, involves the collection of metadata from telephone calls. These are telephone records maintained by the phone companies. They include the number that was dialed, the date and time of the call, and the length of the call. They do not include names or other personal identifying information. They do not include cell site or other location information, and they do not include the content of any phone calls. These are the kinds of records that, under long-standing Supreme Court precedent, are not protected by the Fourth Amendment. The short court order that you have seen published in the newspapers only allows the government to acquire these phone records. It does not allow the government to access or use them. That is covered by another, more detailed court order. That court order provides that the government can only search the data if it has a reasonable, articulable suspicion that the phone number being searched is associated with certain terrorist organizations. Deputy Director Inglis will explain in more detail how this process works. But suffice it to say that there are many restrictions imposed on NSA to ensure that only properly trained analysts may access the data, and that they can only access it with reasonable, articulable suspicion as a predicate and when it has been met and documented. The documentation of the analyst's justification is important. It exists so that it can be reviewed by supervisors before the search is done and audited afterwards to ensure compliance with the court's orders. In the criminal context, the government could obtain these types of records with a grand jury subpoena without going to court. But here, we go to court every 90 days to seek the court's authorization to collect the records. As part of the renewal process, we inform the court whether there have been any compliance problems, and if there have been, the court will take a very hard look and make sure we've corrected these problems. As we've explained before, the 11 judges on the FISA court are far from rubber stamps. Instead, they review all of our pleadings thoroughly, they question us, and they don't sign off until they are satisfied that we have met all statutory and constitutional requirements. The 702 program is different. Under that program, the government does collect content of communications. Under 702, the government applies to the FISA court for an order allowing it to collect the communication of non-U.S. persons reasonably believed to be overseas. This order lasts for 1 year. The statute does not allow us to collect communication, does allow us to collect communications, even if the person on the other end of that phone call or email is in the United States or a U.S. person, but only if that is the result of a non-U.S. person outside the United States having initiated the call. Importantly, the statute explicitly prohibits us from what is known as reverse targeting. We can't use Section 207 indirectly to obtain the communications of U.S. persons anywhere or any persons located in the United States by targeting a non-U.S. person overseas. Moreover, all U.S. person information collected is subject to what we call minimization rules. These rules are designed to restrict the dissemination, the use, and the retention of the information about U.S. persons collected. These rules are reviewed and approved by the court every year to ensure that we are handling U.S. person information in a manner consistent with the statute and the Fourth Amendment. Both programs involve significant oversight by all three branches of government. The FISA court reviews and approves the certifications and the government's targeting and minimization rules, and it oversees the government's compliance with these rules, the statute, and the Fourth Amendment. Within the executive branch, multiple parts of the government, NSA, its Inspector General, the Office of the Director of National Intelligence, and the Department of Justice conduct robust compliance reviews and provide extensive reports on implementation and compliance to the FISA court and to the Intelligence and Judiciary Committees. And Congress conducts oversight, decides whether to reauthorize the 702 authority as it did in 2012 and as it did with 215 authority in 2011. We take very seriously our responsibility to the American people to implement these programs in a manner that complies with all laws and the Constitution and strikes the right balance between protecting their safety and their privacy. I know others on the panel have brief statements to make, and then we are all ready to answer any questions you may have. Thank you.
Thank you, Mr. Cole. Mr. Litt, welcome.
Thank you, Mr. Chairman, Mr. Ranking Member. We appreciate your having this hearing. We think it's very important to correct some of the misimpressions that have been created about these activities, which, as the Deputy Attorney General explained, are entirely lawful and appropriate for protecting the nation. In my opening statement, I'd like to make three related points about the Foreign Intelligence Surveillance Court. The first is that the activity that this court regulates, which is the acquisition of foreign intelligence for national security purposes, was historically outside of all judicial supervision. In fact, courts have held that the Fourth Amendment does not require a warrant at all for the conduct of surveillance for foreign intelligence purposes. FISA was passed in 1978, and at that time established for the first time a requirement that we get a judicial order in order to conduct certain kinds of foreign intelligence or counterintelligence activities within the United States. But at the time FISA was passed, it was clear that the Congress did not intend that FISA would cover electronic surveillance directed at non-U.S. persons outside of the United States for foreign intelligence purposes. And as you noted in your opening statement, because of technological changes in the way international communications are carried, over time, more and more of such surveillance, that is to say, foreign intelligence surveillance directed at non-U.S. persons outside of the United States, more and more of that began to fall within the technical definitions that required FISA court approval, even though that was not what Congress had intended. So in the FISA Amendments Act, Congress set up the procedure of Section 702, which the Deputy Attorney General described, to provide a degree of judicial supervision over some kinds of foreign intelligence surveillance of foreigners outside the United States. Properly viewed, then, Section 702 is not a derogation of the authority of the FISA court, but an extension of the court's authority over a type of surveillance that Congress originally had not intended would be subject to the court at all. The extent to which this nation involves the courts in foreign intelligence surveillance goes well beyond what is required by the Fourth Amendment and, I think, beyond what other countries require of their intelligence services. The second point I want to make is to forcefully rebut the notion that some have advanced that the FISA court is a rubber stamp. It is true that the court approves the vast majority of applications that the government presents to it, but that does not reflect any independence or lack of care on the part of the court. Quite the contrary, the judges of the court and their full-time professional staff review each application carefully, ask questions, and can request changes or limitations. And an application is not signed unless and until the judge is satisfied that the application complies with the statute and the Fourth Amendment. These are some of the best and most experienced federal judges in the country, and they take seriously their twin obligations to protect national security and to protect individual rights. Finally, we agree with the ranking member that we should strive, and the chairman, that we should strive for the maximum possible transparency about the activities of the court, consistent with the need to protect sensitive sources and methods. We have been working for some time to declassify the court's opinions to the extent possible. But legal discussions in court opinions don't take place in a vacuum. They derive from the facts of the particular case. And I want to quote here from Judge Walton, who is now Chief Judge of the FISA Court, who said in a letter to the Senate Intelligence Committee, quote, "Most FISC opinions rest heavily on the facts presented in the particular matter before the court. Thus, in most cases, the facts and legal analysis are so inextricably intertwined that excising the classified information from the FISC's analysis would result in a remnant void of much or any useful meaning." Close quote. That's an excellent and pithy summary of the challenge we face in trying to declassify these opinions. Of course, as you know, we do provide copies of all significant opinions of the FISC to the Judiciary and the Intelligence Committees of both houses. And I can tell you that in light of the recent disclosures, we are redoubling our efforts to try to provide meaningful public insight into the rulings of the FISA court, again, to the extent we can do that consistent with the need to protect our intelligence activities. With that, Mr. Chairman, I'm glad to answer any questions that you have. Thank you.
Thank you, Mr. Litt. Mr. Inglis, welcome.
Good morning, sir. Mr. Chairman, Mr. Ranking Member, members of the committee, thank you for the opportunity to join with my colleagues here today from the executive branch to brief and discuss with the committee issues that you've identified in your opening remarks. I'm privileged today to represent the work of thousands of NSA, intelligence community, and law enforcement personnel who employ the authorities provided by the combined efforts of the Congress, federal courts, and the executive branch. For its part, NSA is necessarily focused on the generation of foreign intelligence, but we've worked hard and long with counterparts across the U.S. government and our allies to ensure that we discover and connect the dots, exercising only those authorities explicitly granted to us, and taking care at once to ensure the protection of civil liberties and privacy. In my opening remarks, I would like to briefly review the two NSA programs leaked to the media a little more than a month ago, their purpose and the controls imposed on their use. The so-called 215 program, authorizing the collection of telephone metadata, and the so-called PRISM program, authorized under Section 702 of the Foreign Intelligence Surveillance Act Amendment. Let me first say that these programs are distinguished but complementary tools with distinct purposes and oversight mechanisms. Neither of the programs was intended to stand alone, delivering singular results that tells the whole story about a particular threat to our nation or its allies. Useful intelligence, the kind decision-makers should use as the foundation of thoughtful action, is usually the product of many leads, some of which focus and sharpen the collection of additional data, some of which help connect and make sense of that data, and the sum of which is intended to yield the decisive and actionable conclusions that enable timely and precise employment of traditional instruments of national power such as law enforcement and diplomacy. The first program, which we undertake under Section 215 of the Patriot Act, as you heard described earlier today, authorizes the collection of telephone metadata only. It does not allow the government to listen to anyone's phone calls. The program was specifically developed to allow the U.S. government to detect communications between terrorists who are operating outside the United States and who are communicating with potential operatives inside the United States, a gap highlighted by the attacks of 9/11. In a phrase, this program is designed and solely focused on the seam between foreign terrorist organizations and the U.S. homeland. However useful the data might be that is acquired under this program for other purposes, its use for any other purpose is prohibited. The metadata acquired and stored under this program may be queried only when there is a reasonable, articulable suspicion, one that you can describe and write down, based on specific facts that a selector, which is typically a phone number, is associated with a specific foreign terrorist organization. During 2012, we only initiated searches for information in this data set using fewer than 300 unique identifiers. The information returned from these searches only included phone numbers, not the content, the identity or location of the called or calling party. Under rules approved by the court, only 22 people at NSA are allowed to approve the selectors used to initiate the search in this database. All queries are audited. Only 7 positions at NSA, a total of 11 people, are authorized to release the query results believed to be associated with persons in the United States. Reports are filed with the court every 30 days that specify the number of selectors that have been approved and the disseminations made to the FBI of reports that contain numbers believed to be in the U.S. The Department of Justice conducts on-site review of the program every 90 days. The executive branch, the Department of Justice, reports to the court and the Congress on renewal orders every 90 days with an update on types of records sought, received, or denied on an annual basis. The second program, which we operate under Section 702 of the FISA, the Foreign Intelligence Surveillance Act, authorizes the collection of communications for the purpose of foreign intelligence with the compelled assistance of an electronic communications service providers, sometimes called telecommunications providers. Under this authority, NSA can collect communications for foreign intelligence purposes only when the person who is the target of our collection is a foreigner who is at that moment outside the United States. As you've heard earlier, we cannot use this authority to intentionally target any U.S. citizen or other U.S. person, any person known to be in the United States, a person outside the United States, if our purpose in targeting that person is to acquire information from a person inside the United States. This program has been key to our counterterrorism efforts. More than 90% of information to support the 50 disruptions that you'll hear my colleague from the FBI briefly describe came from Section 702 authorities. A bit more about oversight. The oversight on these programs operates under controls both internal and external to NSA, including actions taken by the Department of Justice, the Office of the Director of National Intelligence. There are regular on-site inspections and audits. There are semi-annual reports provided to the Congress and the Foreign Intelligence Surveillance Court. The men and women at NSA are not simply committed to compliance with the law and the protection of privacy and civil liberties, but they are actively trained and must be held accountable to standards for that performance. This is also true of contractors. The actions of one contractor should not tarnish all contractors because they also do great work for our nation. In concluding, I would note that our primary responsibility at the National Security Agency, not alone, but across the federal government, is to defend the nation. These programs are a core part of those efforts. We use them to protect the lives of Americans and our allies and partners worldwide. Over 100 nations are capable of collecting signals intelligence or operating a lawful intercept capability like the one you're hearing described today. I think our nation's amongst the very best in protecting privacy and civil liberties. We look forward to the discussions that you've encouraged today, but I also appreciate that this discussion takes place at an unclassified level. I especially appreciate that the committee chairman and the committee have allowed for the possibility that we might have classified discussions in an appropriate setting, because the leaks that have taken place of classified information have constituted an irresponsible and real damage to the capabilities that we will describe today. Finally, whatever choices are made by this nation on the matter before us, in consultation and collaboration across the three branches of government, I assure you that NSA will faithfully implement those choices in both spirit and mechanism. To do otherwise would be to fail to take the only oath that we take to support and defend the whole of the U.S. Constitution. That includes the protection both of national security and civil liberties. Sir, I look forward to your questions.
Thank you, Mr. Inglis. Ms. Douglas, welcome.
Thank you, and good morning, Chairman Goodlatte, Ranking Member Conyers, and members of the committee, and thank you for an opportunity to be here today. As you know, NSA and FBI enjoy a unique relationship, one which has been invaluable since the events of 9/11. The authorized tools available under the Business Records 215 and FISA 702 complement many of the other investigative tools we apply toward national security cases. Together with human sources, physical surveillance, and other logical investigation, 215 and 702 play a role in providing us a more full understanding of our risks and gives us an opportunity to proactively address national security threats. I'd like to give you just a few examples of where these tools have played a significant role, specifically in counterterrorism investigations. And the first case I want to note is one that is very familiar to this committee, and that's of Najibullah Zazi. In early September 2009, NSA, using their authorities under 702, intercepted a communication between an al-Qaeda courier located in Pakistan and an unknown U.S.-based person. This U.S.-based person was inquiring about efforts to procure and use explosive materials, and there was some urgency in his communication. NSA advised the FBI as to this communication as it represented a potential imminent threat to the homeland. Based on the nature of the threat information, the FBI initiated a full investigation and submitted a national security letter to identify the subscriber. The subscriber came back to an individual named Najibullah Zazi located in Denver, Colorado. Additionally, NSA ran a phone number identifiable with Mr. Zazi against the information captured under 215. NSA queried the phone number and identified other Zazi associates. One of those numbers came back to Addis Mudajanan, an Islamic extremist located in Queens, New York. The FBI was already aware of Mr. Mudajanan, but information derived from 215 assisted in defining Zazi's network and provided corroborating information relative to Mudajanan's connection to Zazi. Just a few weeks after the initial tip by NSA, both Zazi and Mudajanan were arrested along with another co-conspirator. They were charged with terrorist acts and a plot to blow up the New York City subway system. As you already know, the Zazi case was the most serious threat to the homeland since 9/11. The importance of the Zazi case is that it was initiated on information provided by NSA, which they acquired under 702, their coverage of an al-Qaeda operative overseas. Without this tip, we can only speculate as to what may have happened. This was a fast-paced investigation and one in which time was of the essence. The combined tools of 702 and 215 enabled us to not only begin the investigation, but to better understand the possible network involved in an active plot to the homeland. I'd like to also represent one case to you specific to the Business Record 215 Authority. In 2003, the FBI initiated a case on an individual identified as Basali Moalan. It was based on an anonymous tip that he was somehow connected to terrorism. In 2004, the case was closed without sufficient information to move forward on the investigation. However, 3 years later, in October 2007, NSA provided a phone number to the FBI with an area code which came back to an area consistent with San Diego. NSA found this phone number was in contact with an al-Qaeda East African affiliated person. Once provided to the FBI, we initiated an investigation, submitted a national security letter for the subscriber of the phone number, and determined that it was Mr. Muwallin, the subject of the previously closed case. Subsequent investigation led to the identification of others, and to date, Muwallin and 3 others have been convicted of material support for terrorism. The relevance of this case to 215 is that if that information had not been tipped to the FBI, it is unknown if we would have ever looked at Mr. Muwallin again. As you know, there are many other instances of the use of these authorities and their application to counterterrorism investigations. Thank you, and I'm happy to answer your questions.
Thank you, Ms. Douglas, and I'll begin that questioning. With regard to the point raised by the ranking member with regard to declassification, I just want to say that with regard to the Section 702 surveillance of non-citizens of the United States outside the United States, I think there would be few Americans who would be surprised that our government engages in intelligence gathering with regard to those individuals, and they would know it even more clearly by looking at the statutes and the amendments to the statutes that have been passed over the years that this type of activity is clearly authorized in the law. With regard to 215, there's some controversy about whether this particular program is authorized under the law, and you'll hear more about that shortly, and I'll have a question myself. But my first question to you is, why would it not have made sense? Given the magnitude of this program, I'm frankly surprised it has remained secret until recently for the several years that it has. Why not simply have told the American people that we're engaging in this type of activity in terms of gathering the information? It doesn't give away any national security secrets in terms of the particular information gathered that might lead to successes like the one just described by Ms. Douglas, but it might have engendered greater confidence in the public with regard to understanding how the program works and public support for it. Mr. Cole, Mr. Litt, would you care to answer that?
Sure. The problem is that I think that a judgment was made that to disclose the existence of this program would in fact have provided information to people who are seeking to avoid our surveillance, that it would tell them that we are looking for the communications they're having with Americans, and we are using that as a basis of tracking them and identifying their confederates within the United States. And so the judgment was made a number of years ago when this program was started that it should be kept classified. It was not, of course, withheld from the Oversight committees in Congress, and as others have noted, it was briefings on it were offered to all members of Congress before it was reauthorized. But the decision was made that this is the sort of sensitive source and method that we don't want to disclose.
Do you think a program of this magnitude, gathering information involving a large number of people involved with telephone companies and so on, could be indefinitely kept secret from the American people?
Well, we tried.
I understand. So let me ask a follow-up question to you and Mr. Cole, and that would be, how exactly does Section 215's wording authorize the government to operate a program for the collection of metadata? Can you walk the committee through the government's interpretation of the statute that lends itself to arguing that you can do metadata collection?
Certainly, Mr. Chairman. I think you have to start with the fact that when you look at 215 and the orders that the Court issues under 215, there's two of them. You can't look at them separately. You have to look at how they interact and operate together. And I think that's very, very important in understanding how this is relevant to an investigation concerning these terrorist organizations. You can't just wander through all of these records. There are very strict limitations on how you can access or how you can use these under what's called the primary order. You have to have reasonable articulable suspicion that a specific phone number, which they call a selector, is involved with one of these specified terrorist organizations. And then, and only then, after you have documented that reasonable articulable suspicion, can you query this database to find out what other phone numbers that specific terrorist-related phone number has been in contact with.
Let me follow up on that question, because how is the collection of all of a telephone company's telephone metadata relevant to a foreign intelligence or international terrorism investigation and investigation?
It is only relevant to the extent that you need all of that information in order to do the query of the reasonably articulated suspicion.
Well, certainly the acquisition of the type of information collected under this program is relevant to an investigation of an individual or group suspected of terrorism, but how do you and how does the FISC rationalize the collection of all of the data as being relevant to an investigation?
There's two main reasons. One is the length of time that these records are kept by the phone companies varies, and they may not keep them as long as we keep them under this program. The Court allows us to keep them for a 5-year period. The phone companies don't necessarily do that. The periods vary, and some can be as short as 15 or 18 months.
Mr. Inglis, with regard to Section 702, what happens if you incidentally collect information from a U.S. person? Can you explain how the minimization procedures apply to that, and what do you mean by minimization?
Yes, sir. There are court-approved rules that we call minimization procedures. What they do is they say that if in targeting a foreign person under 702 who you believe to be in a foreign location to derive foreign intelligence, you discover that you have also collected a communication that involves a U.S. person. They might be the person who has received that communication from your person of interest. They might be the person who sent that communication. They might be referenced in that communication. We have an obligation to first examine whether or not that communication is pertinent to foreign intelligence. If the communication is pertinent to foreign intelligence, then we must take further action to essentially protect the identity of that U.S. person unless knowledge of that identity is important pursuant to the foreign intelligence purpose. We would therefore suppress the identity of that U.S. person in any report that we would make that focused on the target of our interest, and we would take action if that communication was not a foreign intelligence reference relevance to essentially destroy that communication in place.
How long do you retain information collected under 702, and you may have just answered it, but is the incidentally collected information about U.S. persons retained as well?
Yes, so the incidentally collected information, unless it is relevant to a foreign intelligence purpose or it is evidence of a crime or imminent death or injury to a person, you would destroy that on site at that time.
And other information, how long is that retained?
You would otherwise retain that for about 5 years, typically in our holdings. Under BR FISA, the information is mandatorily destroyed at 5 years. For most of the rest of our collection, 5 years is the reference frame. We've found that over time, at about the 5-year point, it loses its relevance simply in terms of its temporal nature.
Thank you. My time's expired. The chair recognizes the gentleman from Michigan, the ranking member, Mr. Conyers, for 5 minutes.
Thank you, Chairman Goodlatte. There is a couple of questions here that haven't come up, and I'd like to direct them to Attorney Douglas. If only relevant conversations can be secured under Section 215 of the Patriot Act, then why on earth would we find now that we are collecting the names of everybody in the United States of America who made any calls for the last 6 years or more?
Sir, we're not collecting names. 215 only collects phone numbers, the time and date of the phone call, and the duration of the phone call.
Well, how do you consider that to be relevant to anything if there is just collecting only the names? And I mean, look, if this is an innocent pastime that we just do to keep busy or for some other reason, why on earth would we be collecting just the names, just the numbers of everybody in the United States of America for at least 6 years?
I can speak to the application against investigations, and in this case for 215, it would be specific to counterterrorism investigations. That information enables us to search against connections to other, if there's a communication between a U.S.-based phone number and a phone number that is overseas that's related to terrorism. And I know that Mr. Inglis explained to you the reasonable, articulable suspicion standard by which we have to actually search against those phone numbers.
Well, here we're faced with the fundamental problem in this hearing. We're not questioning access. We're talking about the collection in the first instance. In the first instance, when you collect the phone numbers of everybody in the United States for over 6 years, there wasn't anything relevant in those conversations. Now you have them, and what I've been getting out of this is that this access may become valuable, Mr. Ranking Member, and so that's why we do it this way. But I maintain that the Fourth Amendment, to be free from unreasonable search and seizure, means that this metadata collected in such a super aggregated fashion can amount to a Fourth Amendment violation before you do anything else. You've already violated the law as far as I am concerned. And that is, in my view, the problem. And of course, to help further document the first question that the chairman of this committee asked is, why didn't we just tell everybody about it? Is because the American people would be totally outraged, as they are getting now as they become familiar with this, that every phone number that they've ever called is already a matter of record, and we skip over whether the collection was a Fourth Amendment violation. We just say that the access proved in one case or two that it was very important, and that's why we did it this way. I see this as a complete failure to take in, we changed the Patriot Act to add relevancy as a standard because of this very same problem that has now been revealed to be existing. And so I feel very uncomfortable about using aggregated metadata on hundreds of millions of Americans, everybody, including every member of Congress and every citizen who has a phone in the United States of America. This is unsustainable, it's outrageous, and must be stopped immediately.
Sir, if I may compliment the answer that Ms. Douglas gave. With respect to the question of relevance, of course, it must be legally relevant, and it must therefore have operational relevance. I'd like to address the operational relevance and then defer to my colleagues from.
Well, you don't. Wait a minute. We're handling this discussion. I ask her. Maybe somebody else can do it, but my time has expired. And I appreciate your volunteering to help out here, but It's clear to me that we have a very serious violation of the law in which the Judiciary Committee deliberately put in the issue of relevance, and now you're going to help me out and defer to somebody else. Well,
no, sir. I meant to actually provide additional information. I'd be happy to take a question for the record if time is not allowing that.
well,
Without objection, the gentleman is recognized for an additional minute to allow another member of the panel to answer the question if he so chooses.
No, I don't so choose. I'm satisfied exactly what I've gotten from the witness that I asked the question to.
The chair thanks the gentleman and
You're
now
welcome.
recognize the gentleman from Wisconsin, Mr. Sensenbrenner.
Well,
5 minutes.
Mr. Chairman, at the risk of having the flag thrown at me for piling on, I want to get at the whole business of who decides what's relevant. Both the chairman and the ranking member have said that the Patriot Act was amended in 2006 to include a relevance standard. Yesterday, I got a letter from the Justice Department, which was at great length explaining this, and I'd ask unanimous consent that this letter be placed in the record at this time.
Without objection, it will be made a part of the record.
Part of that letter said that, in effect, that all of the phone calls, meaning the telephony metadata, had to be collected pursuant to the court order. And then it would be up to the security apparatus to make a determination of which needles in that large haystack were relevant to a foreign terrorist investigation. Now, doesn't that mean that instead of the court making a determination of relevance, it's the security apparatus that makes a determination of what's relevant and which of the less than 300 series of phone calls get picked out according to your testimony? Mr. Cole, would you like to answer that?
Yeah, Mr. Sensenbrenner, I'm happy to address that. What the court does is it sets out a framework and a set of rules that we must follow to implement its orders.
But they don't determine which specific phone calls are relevant pursuant to the statute. You do that.
Well, we report to the court periodically on the implementation of this. We get it re-upped every 90 days when there are...
But you do that. The court does not.
The court does not.
Now, if there was a criminal trial involved, it would be the court that would be determining a relevance standard pursuant to subpoena or for proffered evidence, wouldn't it?
Not necessarily, Mr. Sensenbrenner.
Okay, well then let me continue on this. You know, I'm Patriot Act and the Patriot Act reauthorization of 2006. Mr. Conyers was correct in saying why the relevance standard was put in, and that was an attempt to limit what the intelligence community could be able to get pursuant to Section 215. It appears to me that, according to this letter and according to the testimony of FBI Director Mueller, that relevant was an expansion of what could happen rather than a limitation when the law was amended when relevant was not included in that statute. And doesn't that make a mockery of the legal standard because you're trying to have it both ways?
I don't think we're trying to have it both ways.
Well, you sure are, because you're saying, you know, have the court authorized to get us the records of all the phone calls that are made to and from phones in the United States, including people who have nothing to do with any type of a terrorist investigation. And then what you're saying is that we'll decide what to pick out of that mass of maybe 1 billion phone calls a day on what we're looking at, rather than saying this person is a target. Why don't you get an authorization only for that person's telephone records?
Again, going to the analogy of the criminal context, we would never, in a grand jury situation or in an investigation that's a traditional criminal investigation, even go to a court for the framework or the setting of rules, or have sunsetting every 90 days of the authority, or having compliance procedures.
But, Mr. Cole, with all due respect, the letter that I got from the department that you're the #2 person in says that you get the FISA court order because there are, quote, reasonable grounds to believe that the data is relevant to an authorized investigation to protect against international terrorism, as Section 215 requires, even though most of the records in the data set are not associated with terrorist activity. So you gobble up all of those records, and then you turn around and say, well, we'll pick out, maybe 300 phone numbers out of the billions of records that you have every day and you store for 5 years there, and all the rest of this stuff is sitting in a warehouse, and we found out from the IRS, who knows who wants to have any kind of legal or illegal access to it. You are having it both ways. And, let me tell you, as one who has fought Patriot Act fights, usually against the people over on the other side of the aisle, Section 215 expires at the end of 2015, and unless you realize you got a problem, that is not going to be renewed. There are not the votes in the House of Representatives to renew Section 215, and then you're going to lose the business record access provision of the Patriot Act entirely. It's got to be changed, and you have to change how you operate Section 215. Otherwise, in a year and a half or 2.5 years, you're not going to have it anymore. Now I yield back.
Chair, thanks, gentlemen. Recognize the gentleman from New York, Mr. Nadler, for 5 minutes.
Thank you. The problem, obviously, Mr. Cole, with what we're hearing from this panel and what we've heard generally about the relevance standard, is that everything in the world is relevant, and that if we removed that, word from the statute, you wouldn't consider, or the FISA court wouldn't consider, that it would affect your ability to collect metadata in any way whatsoever, which is to say you're disregarding the statute entirely. Now, in public briefings, including to this committee when we were considering the authorization of Section 215, administration officials have suggested that we view the authority of Section 215 as similar to a grand jury subpoena. And we specified in the statute that an order under Section 215, quote, may only require the production of a tangible thing if such thing can be obtained, unquote, through a grand jury subpoena. Now, can you give me, Mr. Cole, any examples where grand jury subpoenas were used to allow the bulk and ongoing collection of telephone metadata?
It's difficult to go into specific examples of what grand jury subpoenas call for because
they
are subject to the rules of secrecy under Rule 6.
Oh, come on. Are there any instances in the history of the United States that you know of where a grand jury subpoena said get all information other than the content of a telephone call of all telephone calls in the United States, or anything like that?
The admonition in the statute is that it is the types of records that are collected by grand jury subpoena, not that it is an identical process to the grand jury process, because this is quite different from a grand jury process.
All right, the type of data, the type of data is metadata unlimited to specific individuals.
The type of data is metadata, and that
unlimited to specific individuals, because it's directed to everybody. It's directed to every phone call in the United States. Can you give me any example where a grand jury subpoena has ever been used for anything remotely like that?
These are instances where we have gone to the court under the 215 requirements with the relevance.
You're not answering my question. Can you give me any example in the history of the United States where a grand jury subpoena was used for anything remotely resembling all metadata, not to specific phones or to specific individuals?
Grand jury subpoenas have a different function than a 215 under the Patriot Act.
I understand that, but the statute
it's hard
says
to equate the two, Mr. Nadler.
You're not answering my question. You're deliberately not answering. We know they have a different function, but the statute says that it may only require the production of a tangible thing if such a thing can be obtained through a grand jury subpoena. Could you obtain through a grand jury procedure all metadata without being limited to specific named individuals or specific listed telephones?
I think it would depend on the circumstances, the limitations that the court...
Okay. Is there any instance in history...
of the investigation, and then, yes, I think there are instances where a court, in the right circumstances, could authorize it.
And could you give me any instance in history where that has ever been done?
I'm not aware of one sitting here right now.
You're not aware of one. Could you supply us, please, with any instance? Because I believe this is totally unprecedented and is way beyond the statute. And you can't give me any instance because it doesn't exist. So within a week or two, could you supply this committee with that information?
Depending on the restrictions of Rule 6 of the Criminal Rules of Procedure, which prohibit disclosing grand jury information, we'll take that record back for response, or that question back for response.
And can you give us an example where ongoing bulk collection has been allowed by virtue of grand jury subpoena without a showing of a connection between those tangible things and a specific existing investigation?
Well, in this instance, we are showing it as a relationship to a specific investigation and a specific phone number. We have to show reasonable...
No, only for use of that information, not for collection of it.
Well,
now, the statute is talking about collection. You're trying to confuse us by talking about use.
But the collection is only there and is only valuable if it is used, and the use is severely restricted.
But we're not talking about the use. The abuse of the statute, the abuse of civil liberties, the abuse of privacy is not only misuse, but miscollection. If you're collecting information about my telephone when you shouldn't be doing that, that is an abuse, even if you simply file that and never use it.
We go to the court and describe to them exactly how the program will work, what the limitations
are. Well, excuse me, that doesn't help me. The fact that let me answer the question.
This collection.
No, the fact that a secret court unaccountable to public knowledge of what it's doing, for all practical purposes unaccountable to the Supreme Court, may join you in misusing or abusing the statute is of no comfort whatsoever. So to tell me that you go to the FISA court is irrelevant if the FISA court is doing the same abuse of the statute. So, again, can you give me some examples where ongoing bulk collection, I'm not asking about use, has been allowed by virtue of grand jury subpoena without showing of a specific connection, without showing the connection between those tangible things and a specific existing investigation?
Time of the gentleman has expired. Mr. Cole, be allowed to answer the question.
We'll take that as similarly as a question for the record, and again, depending on the rules of criminal procedure, we'll see what we can get back to you, sir.
And be aware, of course, that you could give it to us on a classified basis so that we could say our conclusions about that information.
Time of the gentleman has expired. The gentleman from North Carolina, Mr. Coble, is recognized for 5 minutes.
Thank you, Mr. Chairman. Ladies and gentlemen, good to have you all with us today. Mr. Cole, let me start with you. Does the Fourth Amendment protection against unreasonable search and seizure apply to business records that could be obtained under 215 of the Patriot Act?
In particular, Mr. Coble, they do not apply to the metadata records. There is a case, Smith versus Maryland, where the Supreme Court ruled that these kinds of cases, there is no reasonable expectation of privacy, so there's no Fourth Amendment protection.
Let me follow up with another question. So does a person that have a reasonable expectation of privacy in third-party business records?
That's correct. People generally do not when they're in third-party hands because other people already have them. So the expectation of privacy has been severely undermined.
Is it true that a 215 order provides greater privacy protection than does a grand jury or administrative procedure or administrative subpoena, which can be used to obtain the same types of business records in a criminal investigation without prior court approval?
Yes, it does. There are a number of provisions in 215 that provide much greater protection than a grand jury process would. First, you have to go to a court. The court has to specifically review the program and the description of the relevance of these records, how they will be accessed, how they will be overseen, how there will be auditing, how there will be reporting on it, how there will be compliance with all of the rules of the court. None of that takes place in the grand jury context.
Mr. Cole, if the Fourth Amendment applies to foreign countries, do other American protections under the Bill of Rights apply, such as the Second Amendment or the Due Process Clause?
Not necessarily, sir. The Fourth Amendment applies to U.S. persons who are outside of the United States, but it generally does not apply to non-U.S. persons who are outside of the United States.
Mr. Cole, for the benefit of the uninformed, and sometimes I feel I'm in that category, Describe for the committee the makeup of the FISA court, who sits on it, where it resides, and how it operates.
The FISA court is made up of judges, Article III judges, who have been nominated by a president. They cover any number of different administrations. They have been confirmed by the United States Senate for a life appointment. They have their regular duties as district court judges. They are appointed by the Chief Justice of the United States to serve a term on the FISA court. There are 11 of them at any given time when you have a full complement. Each of them serves for a week at a time. They do not take care of their other court duties back in their home districts. They come and serve on the FISA court for that week, handling the applications. There is a staff there as well that helps them and goes through it. And is their clerks and some of their legal research assistants in this matter. And these last for, I believe, a term of 7 years that each judge can sit on the court.
And I believe you, Mr. Cole, or one of the members of the panel may have indicated this, that to some extent there is confusion as to the number of denials. There's been criticism level at the court indicating very few denials, but I think you addressed that, well, one of you addressed that earlier in your comment. You want to add to that?
Yes, the level of denials is very similar to the same level of denials, which is small for normal Title III in a criminal context, wiretap applications that are made to judges in regular courts. These are also done in chambers and with one party. And the reason that the number is so low, first of all, is under the FISA, you have to have either the Attorney General or myself or the Assistant Attorney General for the National Security Division sign off on the application, very high-ranking officials in the department. So those applications are done very carefully in the first place. Number two, the court, if they're not satisfied with an application that comes in, will tell us. And they'll say, you need more information. You need more restrictions. You need more requirements. So we will respond to that. And unless we satisfy them on all of their requirements, they will not sign them. But more often than not, we can go back and find the additional information that they will need. So there is something of an iterative process, but it's not unlike what goes on with a normal court every day in the Title III or the wiretap process.
I thank you, Mr. Cole. Mr. Chairman, I see my amber light. I'd like to make one final statement, and this may not be the day for it, but Mr. Chairman, at some point, I'd like to know the cost that has been expended in implementing this matter. If you would concur with that, I'll pursue that at a later date.
I do concur with that. It's a very important piece of information to have, but I believe that is classified and would entail the subsequent hearing that I anticipate we will have in a classified setting where we can get answers to questions like that.
I thank you, Mr. Chairman. Good to have you all with us. I yield back, Mr. Chairman.
Chair thanks the gentleman and recognizes the gentleman from Virginia, Mr. Scott, for 5 minutes.
Thank you. Mr. Cole, did I understand you to say that you do not have an expectation of privacy on your phone records?
The Supreme Court ruled in Smith versus Maryland that you do not have a sufficient expectation of privacy in the phone records, as we've talked about it. The two.
Okay, that's fine. Ms. Douglas, you indicated that you do not. You just get the numbers, not the names. Is there, if the numbers are relevant under whatever standard you're using, why are not the names equally relevant?
Well, the names are not collected in the metadata.
Well, I mean, where's the limitation? If you can get the numbers, why can't you get the names?
Well, we can through other legal process, and that's what the FBI will do. And so if we receive a phone number...
well, no, I mean, why don't you get it all at once? Where's the statutory limitation?
If I can answer the question here, I think that this indicates the fact that, as the Deputy Attorney General said, that this program is carefully set up in such a manner as to minimize the invasion of privacy. One of the reasons
where is the statutory limitation?
This program is found reasonable is the fact that the collection is very limited, the access is very limited.
Okay.
And it's on that basis.
You have made up
collection.
That's because you have made up the program. I asked you a specific question where if this is available, where is the statutory limitation to what you can get? There is no statutory limitation. You're kind of making it up as you go along.
We're not making it up. We're seeking the approval of the court, and this collection has been repeatedly approved by numerous judges of the FISA court, found to be in compliance with the statute.
Okay, once you get the information, we know through the recent case on DNA, once you get DNA from somebody, you can use it in ways that you could not have obtained the information, but once you get it, you can run it through no probable cause or anything through the database. My question is, once you get this metadata, where's the limitation on what you can use it for?
It's in the court's order.
Where is the statutory limitation?
The statutory limitation says that we can acquire the information as ordered by the court. The court sets limits on what we can do with it, and we adhere to those limits.
Well, is there a limit in criminal investigations or an exception for criminal investigations without probable cause?
With respect to information obtained under Section...
Once you've got the metadata, can you run a criminal investigation without probable cause?
The metadata can only be used in pursuit of a terrorism investigation, and the only thing that is done with that is that telephone numbers are generated out of it for further investigation. And it cannot be used for a criminal investigation unrelated to terrorism.
Wait a minute. Well, wait a minute. No, you're talking about minimization?
The court's order provides that we can only use this data for purposes of a terrorism investigation.
Well, how does the court get to? Why is the court required to place that limitation on it?
Because the court looks at the application that we are submitting and determines that with all of the restrictions that are imposed here, this is a reasonable method of collecting this information, and that it complies with both the statute and the Fourth Amendment.
Is there an exception under minimization for criminal investigations? Section G, minimization procedures, 2C says that notwithstanding subparagraphs A and B, procedures that allow for the retention and dissemination of information that is evidence of a crime which has been, is being, or about to be committed, and that is to be retained or disseminated for law enforcement purposes, are exempted from the minimization requirements.
The procedures applicable to this kind of collection allow it only to be used on the terms specified by the court, and that is limited to generating talked about in pursuit of a terrorism investigation.
Okay, and so the minimization exception for criminal investigations doesn't apply? If you trip over some criminal, some crimes,
we're not allowed to use this database for a criminal investigation unrelated to terrorism.
Mr. Scott, I think
then that's not what the code section says. But if that's what you want, maybe we need to change it. Does exclusionary rule apply? If you trip over some crimes and try to use it, and including the principle of the poison tree, evidence of a poison tree, does that apply? Do those exclusions apply to stuff you may trip over that you've gotten through this?
We don't have the ability to trip over it in this. All this data is a series of telephone numbers and other identifiers. The only thing we can use this data for is to submit to the pool of data a telephone number or other identifier that we have reason to believe, based on articulable facts, is associated with terrorism. We can then say, what numbers has that been in contact with? Any other further investigation has to be done under some other authority.
Well, you have, Mr. Chairman, I apologize, but the limitation, the minimization exception for a criminal investigation, and when I asked the Attorney General Gonzalez about what you could use this information for, he specifically indicated criminal it's G2C under minimization requirements, procedures. He specifically said you could run a criminal investigation without the necessity, implying without the necessity of probable cause that you usually need to do to get information. Thank you, Mr. Chairman.
The Chair thanks the gentleman. Recognize the gentleman from Alabama, Mr. Backus, for 5 minutes.
Thank you. Let me start by saying I'm satisfied, at least from what limited knowledge I have, that the motivation behind this was legitimate and necessary for our national security to start this process. Establishment of a court, and that from your testimony, you've apparently not abused individual rights, and you have been effective too for terrorism. But my concern is this could evolve into something that is quite different. The Star Chamber, I mean, in England, started as a very good, very popular with the people. It allowed people to get justice that otherwise would not. But it evolved over time into a powerful weapon for political retribution by the king. And my question is, in fact, I was reading the Supreme Court. It said it symbolized disregard of basic individual rights. They talk about actually the right against self-incrimination was a direct result of what happened in England when this court evolved into something quite different from what it was intended to do. So my first question to all of you is, how do we keep this from evolving into a weapon, an unchecked weapon by the government to violate people's constitutional rights? And I'm more concerned about Americans' rights, not terrorists' rights.
I think you raise a very excellent point, and I think the way this is designed to make sure that all three branches of government are involved, that this isn't just the king or the administration or an executive branch doing it. This is something that is done with permission of the court and supervision of the court, with rules laid down by the court to make sure it comports with the Constitution and the privacy rights of U.S. citizens. It's done through statutes that are passed by this body, where we report back to this body and tell you what we have done with it and how it works, and let you know what problems we've had and how we fixed them. And it is also done with a lot of oversight within the executive branch, with inspectors general and a number of different executive branch agencies that audit and oversee exactly how it's done and make sure it's done right. I think that's how.
If I can just emphasize one point on that, this committee has a very important role in ensuring that these authorities are not abused. We are required to report extensively on all activities under FISA to the Intelligence and Judiciary Committees of both houses, and we do that. We're required to provide copies of all significant opinions. We're required to provide reports about how these activities are carried out. And we welcome your participation in that oversight to ensure that, in fact, we don't cross the bounds that the people want us to adhere to.
Anyone else? When I learned about this, I was not aware of it at all, and I think the original response was that 14 members of Congress knew something about this. Were those reports erroneous?
I can't speak to what members actually knew. I can tell you what we did to inform members. At the time when this legislation was first up for renewal in 2009-2010, we provided a classified letter to the intelligence committees that described this program in great detail.
How about the Judiciary Committee?
The letter was provided to the Intelligence Committee. The Intelligence Committee, my understanding, has sent an all-member letter saying that this is available to all members. This was our intention. We also offered classified briefings to members of this committee, and I recall participating in one of those briefings. And in fact, the letters were also referenced in a statement on the floor by a member of the Intelligence Committee saying these letters are available and I urge you all to come and read them. So we were not trying to hide this program.
Do you have any objection to the court opinions and periodic reports being made available to all members of Congress?
I think we'd have to take that back. I think the answer is probably no, but I think we'd have to think about the implications of that.
Sure, and I think that's my response would be I want to think about it.
Time of the gentleman has expired.
Thank you.
The gentlewoman from California, Ms. Lofgren, is recognized for 5 minutes.
Well, thank you, Mr. Chairman, and thanks to our witness. I was thinking back to September 11th, one of the worst days I've ever spent in the Congress, and remembering that weekend after the attack, that members of the White House, the intelligence community, members of this committee and our staff sat right at that table. We sat around that table and worked together to craft the Patriot Act. And it's worth remembering that that original act was passed unanimously by the House Judiciary Committee. And it had the balance that we thought was important to protect the country, but also to, looking forward, to protect the rights of Americans under the Constitution. And I share the concern expressed by Mr. Sensenbrenner that things have gone off in a different direction from that day. Now, as my colleague has indicated from Alabama, I don't question your motivation, which is to keep America safe. I mean, I know that that's what you're trying to do, and certainly we all want that. But the concern is that the statute that we crafted so carefully may not be being adhered to as envisioned by us and as reported to us. And I just want to say this. I mean, yes, we have a system where there are checks and balances, but part of that is that the legislative branch needs to have understanding of what the executive branch and the judicial branch is doing, and we can't do that without information. It's been discussed that we get these ample reports. And I just recently reviewed the annual report on Section 215. Is it true, Mr. Cole, or isn't it true that the annual 215 report to the committee is less than a single page and not more than 8 sentences?
I think that the 215 annual reports are quite a bit less than the 702 annual reports.
I just asked the question. Is that about the size of your recollection?
I'd have to go back and answer specifically.
Is it true that the report of the number of applications really gives the committee information as to the amount of records and the number of entities impacted?
I'm sorry?
The number of applications, is there a direct correlation between the number of entities impacted by those applications or the number of records?
The number of entities impacted will depend on how many phone numbers have been called.
Right, so you could have report the number of applications, but it would have no relationship to the amount of records actually acquired.
It would not necessarily, no, but you can.
Thank you very much. Looking at this letter that was sent to Mr. Sensenbrenner, and I thank him for sending it out. And by the way, he and I have sent a letter to Attorney General Holder and to Director Clapper asking that U.S. companies be authorized to publish information regarding the government requests for user data under FISA. I think it's terribly unfair that these companies that are being discussed around the world have no capacity legally to say what has been asked of them. So I know the letter was just sent. I would ask that you respond to that as promptly as possible, just out of basic fairness to the companies involved. But going back to the letter, it seems to me that if you take a look at page 2 of the letter, the second paragraph, it indicates that NSA has reported in the last calendar year fewer than 300 unique identifiers. This means that only a very small fraction of the records is ever reviewed by any person and is actually relevant to the records. Per se, that sentence indicates that getting all the data is clearly not relevant to a specific inquiry. And then if you go on to the next page, and this really gets to my question, and you've referred to it in the testimony as well, the consistency allegedly with the Constitution. Now, it's true that the Constitution in the Smith case indicated that there's no expectation of reasonable expectation of privacy with information held by third parties. Is it your position that that constitutional provision trumps a statute? Can the Congress say the Constitution would allow you to capture every phone record, every photograph taken of an American at an ATM machine, because that's in plain sight, and that constitutional provision would trump the ability of Congress to say, no, we're going to authorize less?
No, as long as whatever Congress does is consistent with or within the bounds of the constitutional provision, they can do that, certainly.
Can do less. I would just like to say that, as to the FISA court, and I'm sure that the judges take their obligation as seriously as you do, but the whole system of our justice system is set up in an adversarial way. And when you have only one party there, you don't have a counterparty making a case before the court. The expectation that our system will work well as it does in other environments, I think, is misplaced. I share with Mr. Sensenbrenner the belief that this will not be able to be sustained. I look forward, Mr. Chairman, to our classified briefing, but I think that very clearly this program has gone off the tracks legally and needs to be reined in, and I thank the Chairman for yielding to me.
Chair thanks the gentlewoman and recognizes the gentleman from Virginia, Mr. Forbes, for 5 minutes.
Thank you, Mr. Chairman, and ladies and gentlemen, thank you for being here today. I don't want to scream at you or yell at you, but we've got a lot of people across the country that would like to do that. And the reason this room is packed so much today and people were waiting in long lines is not just about this program. They kind of feel their country is shifting, and they feel, rightly or wrongly, that this administration has adopted the philosophy that somehow the end justifies the means. They feel like that more than any administration in history, this is an administration that's used taxpayer resources to advocate their political agendas. They feel like more than any administration in history, this is an administration that has decided which laws they want to obey, which ones they want to ignore, and which ones they want to just rewrite. They feel like more than any nation in history, this is an administration that's used the enormous power of government agents to oppress and harass U.S. citizens like they've seen with the IRS. And now they see this administration using this unprecedented amount of data collection, first in their campaigns and then in government, on amounts of data to use for the aforementioned goals. And they don't know, every time they see a Benghazi, they don't know how many more boards they're going to pull up, and there's one that they don't know about, or IRS programs that they pull up and they don't know another one that they might see, and that there are other data programs that they don't know about. And this is something that I just don't think we realize enough, because over and over again we hear administration coming over here and saying this to us. They say, well, this isn't illegal, and you need to change the law. And we need to emphasize, part of this committee is just because something is not illegal, it doesn't mean that it's not wrong. And when we look at something, you've got a difficulty because you can't even really come in here and explain what this program does. You can't tell us how many people are involved with it. You can't tell us the cost. You can't tell us what the court is saying. But this is my question for you. There has to be an enormously large number of individuals administering this program. Can you tell us if any of those individuals have abused the power that they have within this program that has not been disclosed to the Congress or the American people? One, because it would be hard for us to believe that there hasn't been some abuses. Number two, what is your process for collecting that information to make sure those abuses don't take place, and how do you distribute that information? And three, has anybody ever been disciplined for abusing that information? And any of you who have that information, I would love for you to offer it to us.
Let me, if I can, Mr. Forbes, start by answering the questions that you've put. First of all, I think it's important to note that this program has been going on across a number of administrations, and it's not unique by any means to this administration. It's been for prior administrations, too. It is also done pursuant to court authorization and pursuant to statute, And so it is done not as some rogue matter, but as some matter that in fact has been authorized by law, authorized by the courts, and carefully scrutinized. And that gets to the main part of the question that you've asked, which is, we know of no one, and I can let Mr. Inglis expand on that, who has ever intentionally or in any kind of wrongful way abused this. There may have been technical problems that have happened here and there, but there has been nobody who has abused this in a way that would be worthy of or cause discipline. This program goes under careful audit. Everything that is done under it is documented and reviewed before the decision is made and reviewed again after these decisions are made to make sure that nobody has done the things that you're concerned about happening. And those are valid concerns, and we take them into account by having these audit procedures and having the reporting that we do in the consultation both with the court and with Congress to make sure that those things don't happen. We have not, to my knowledge, disciplined anybody for this because our controls make sure this doesn't happen. But we do look for it, and we look for it hard, and we haven't found it.
Sir, if I concur with Mr. Cole's remarks. Across my time, I've been the Deputy Director now for 7 years. There have been no willful abuse of the 215 or the 702 program. In fact, the Senate Select Committee on Intelligence in the summer of 2012 said that in a formal report that in a 4-year review that they had detected no willful abuse of the 702 program. I would say, how would those be identified? In much the same way that Mr. Cole talked about, that there are a number of processes that review the formation of the selectors, the results generated by those selectors, not just at NSA, but between NSA and the Department of Justice and the court. And there are any number of opportunities then to turn up a misappropriation of the resources dedicated to this program for some other purpose. And would those persons who abuse this program then be disciplined? Of course they should be.
And my time has expired, and I don't mean to cut you off, but I'd love to have your responses for the record. But when you guys tell me nobody's abused it, I thought Mr. Snowden abused it pretty badly. And, you know, I can't imagine if we have somebody like that doing it that we don't have at least that capacity. But I'd love to have your responses for the record because I don't want to abuse other people's time. And, Mr. Chairman, I yield back my time.
Mr. Inglis, if you care to respond to the gentleman from Virginia's comment about Mr. Snowden, we'd be happy to have it.
So I'd be happy to take that question for the record, but would say here for the record that we do not have any evidence that Mr. Snowden abused the program as we've defined it today. He may have abused his trust in disclosing classified details of that program.
But in all due respect, and I said I wasn't going to yell at you, and I'm going to try not to, but that's exactly what the American people are really worried about, that somebody's getting their data and using it to disclose it in some other situation. And for the life of me, I don't understand how you guys parse that issue that's there. So, Mr. Chairman, that's what's infuriating the American people. They're understanding that if you collect this amount of data, people can get access to it and use it in ways that can harm them, not just the United States of America. And that's what's concerning them, I think, in a lot of areas. So, Mr. Chairman, I hope we can get a more elaborate response maybe for the record.
Response for the record, sir.
Chair thanks the gentleman and recognizes the gentlewoman from Texas, Ms. Jackson-Lee, for 5 minutes.
Let me thank you very much, and I think it's important to make sure that as those of us who represent Americans, we appreciate what the intelligence community does. But the very idea that the chairman and ranking member has held this hearing and that you're having any number of hearings, I think the issue is that we have to do something. We have to do more to be able to ensure the trust of the American people. And I raise these questions in the context of that. One point that our ranking member made, that if we cannot prove the necessity of this mega data collecting, then why are we necessarily doing it? And then we join with the chairman that says that it must show value, but we must also have the premise and the respect for the civil liberties of the American people. So I pose the first question that deals with the idea that witnesses have testified in recent hearings that phone record data were queried 300 times last year. How do you define a query, and how do you define the necessity of what I call trolling? And someone wanted to have me rephrase that, but the gathering of millions and millions, the mega data gathering, how do you define query first, but then how do you justify that gathering?
Yes, ma'am. I'll take that question. So first, the court has approved procedures by which we can form a selector. The reasonable articulable suspicion standard was what we described earlier. And less than 300 times in 2012, we approved a selector for entry into the database. The court also approves what's called...
So the query is based upon permission by the FISA court?
Yes, ma'am. The FISA court approves the rules, but as we've described in this hearing, the decisions about how to form those selectors are made at the National Security Agency and subject to auditing and review.
So the query is made without a warrant. You go by criteria that's been set, and then you make a query and a preliminary oversight, if you will. Is that what you're saying?
That's correct, ma'am. And can I just then add that the court has also given permission to do not just first hop analysis, meaning what numbers are in contact with that selector, but to then from those numbers go out 2 or 3 hops. In many of the cases that Ms. Douglas referenced earlier, it was at the second hop. It was at that second connection that something of interest came that then caused the Federal Bureau of Investigation to apply their resources to essentially uncover or add additional information to terrorist activity.
Once you do the query out of the 300, then what are the next steps?
So that query, when it's returned, can be a first hop query or second or a third hop query. That information is then reviewed by the National Security Agency analyst, and a report would be written and disseminated to the Federal Bureau of Investigation if we see something that would be of interest to them. In many cases, when a query is performed, nothing of consequence turns up. No connections that are untoward turn up. Therefore, no report would be made.
Let me ask Mr. Cole. Thank you very much. Let me ask Mr. Cole, when does the DOJ become engaged? The FBI, of course, is the investigatory arm. What is the DOJ's oversight role more specifically, and how do you utilize the FISA court? And as you do that, I have introduced bipartisan legislation dealing with the whole issue of the FISA court. It specifically asks for the release and the reporting of non-classified opinions, which I think would contribute more to the trust of the American people. Would the Justice Department consider that as you answer the question?
Thank you, Ms. Jackson-Lee. Certainly we will consider that and work with you in regard to that. The Justice Department's involvement here is to first make sure that the provisions of the statute in making the application to the court meet the standards that have been set out under law. So we are in the process of the application and making sure through legal advice that this in fact meets the standards set out by the statute as passed by Congress. We also engage with the court for any questions that the court may have as to how this will be done, what kind of oversight will be done, what kind of limitations will be done, so that we end up with what is a court-authorized system as described by Mr. Inglis, where we go and make those and have NSA make that determination. We audit as well the determinations on a random basis to make sure that they are in compliance with what the court has ordered. And if they are not in compliance, we will then report that to the court and then oversee with the court's supervision fixing those compliance issues to make sure that they do comply.
Let me interrupt you so I can just get this last question into Mr. Inglis. Mr. Inglis, thank you very much. Mr. Inglis, let me just put this question out. We've had a release of data and a suggestion that the release that has been given by an individual that is now traveling around the world has a dastardly impact on knowing the system of collection of data in the person of Mr. Snowden. Can you speak generally to the idea of the impact, and can you also express the reason for 70% of the intelligence budget being used for contractors? I offer to you 2434 that is asking for a study for that, bill that I've introduced, but I would like to know those two questions quickly, please.
Yes, ma'am. On the first question, I would say that the impact associated with Mr. Snowden's disclosures can be very, very harmful. It's too soon to tell whether, in fact, adversaries will take great note of the things that he's disclosed, but those capabilities, sensitive capabilities, give them a playbook as to how they would avoid, the time and attention of the U.S. foreign intelligence and, for that matter, domestic intelligence organizations. So we're very concerned about that. Mr. Litt would like to take the second question on contractors.
On the question about contractors, it's important to differentiate between two kinds of contractors. When Lockheed Martin or somebody builds a satellite for us, that's a contract. And so when you talk about 70% of the budget being contractors, and I don't know that number offhand, but I'll assume it's accurate, that includes all the contracts for building of satellites, for rental of space, and so on and so forth. There's another category of contractors, which we call core contractors, which are the people who work in the building side by side with us. We have been working very hard to reduce the number of core contractors. I think in the last 5 years we've reduced it by 36%. Obviously, as a result of what's happened recently, we're looking again at whether certain categories of employees should not be contractors but should be made government employees.
Mr. Litt, we've
Time
had
of
this
the
discussion
gentleman,
before.
time of the gentleman has expired.
I'd like to work with you on the legislation. Thank you, Mr. Chairman. I'd like to work, Mr. Litt, to get that done and get that more.
The time of the gentlewoman has expired. The
I yield back.
From Iowa, Mr. King is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate this hearing and the testimony of the witnesses. And I'd first turn to Mr. Litt, and if I remember in your opening statement, you made mention that there wasn't a restriction on foreign intelligence surveillance up prior to 1978 and the FISA court. Am I correct on that?
Yeah, there was no judicial involvement.
And I would submit that every nation that I know of does foreign surveillance, and I don't know of other nations that have judicial interference with the national security activity of foreign surveillance. And are you aware of any?
I can't speak for every nation, but I think generally speaking you're correct that other nations do not have their courts involved in foreign intelligence activities.
So we're relatively unique in that, and neither do I understand why we'd be concerned about the privacy or the, I'll say, the manufactured constitutional rights of foreign persons in foreign countries communicating with other foreign persons in foreign countries. I don't know why we'd worry about their privacy. And I don't know why we'd worry about their privacy if there's a nexus that might happen to be in the United States, provided it didn't interfere with the rights of a U.S. person. Would you agree with that?
Well, I think from the point of view of the Constitution, it's correct that, as the Deputy Attorney General said, that foreigners generally aren't protected by the Constitution. It's nonetheless true that we don't go out indiscriminately even as to foreigners. We only collect intelligence that has a valid foreign.
I understand the decency of the American people, but are we safer when we have judges deciding what we can surveil in foreign countries when they're foreign persons?
I think that we have found that the operation of FISA so far has allowed us to collect the foreign intelligence that we need to collect to protect the nation.
Yeah, I'm hearing that. Just another way of asking questions about this. The phone companies collect a lot of data, and it was mentioned that you'd like to keep that data for 5 years, the metadata, but some only keep it for a year and a half. If an agreement could be reached with the phone companies to maintain that data for a 5-year period of time, the duration that you request, wouldn't that be a firewall that would be more reliable than having to have the facility to store all that data? And certainly, Mr. Inglis.
Yes, sir. A reasonable question. I think that there are some challenges that could be overcome. The first is that those companies collect that data for their own business purposes, not necessarily for the governments. And so to rely upon what they hold themselves, there'd have to be some basis by which you could either compel them or have some confidence that over time.
Contractual agreement, perhaps?
Pardon, sir?
A contractual agreement, perhaps?
Contractual agreement, possibly some liability protection. I'll leave the legal framing of that to those who do statute and policy. 2, you'd have to have some confidence that you could efficiently, quickly query that data.
Sure.
And so if you had multiple providers, upwards of more than 2 providers, you would then run pillar to post querying that data.
Could I ask you to take a careful look at that and come back to me with really a serious reasoned answer? You give me a good answer so far. I'd just like you to dig into it.
Yes, sir, we will.
Deeply.
So it turns out that the Senate Select Committee on Intelligence, House Permanent Select Committee on Intelligence, and the Executive Branch have all asked us a question along those lines.
Curious.
We'd be happy to provide those.
Well, my clock is ticking down, but I'll stick with you, Mr. Inglis. Now, I'm just going to ask this question, and it's not really hypothetical, but point it out this way. And I'm going to go through the list, so let's check on each one, and I'll come back if I need to. Do we have the ability to not necessarily listen in, but track every phone call in the United States? That's one question. Second one, do we have the ability to track any email in the United States? Do we have the ability to track website activity, any website activity in the United States? Do we have the ability to enter into active chat rooms and in real-time monitor? Do we have the ability to track any electronic credit or debit transactions, including the ATM transaction mentioned by the gentlelady from California? Do we have the ability to locate cell phones that are active? Do we have the ability to track GPS locators, whether they're on vehicles or other devices? And then, I know my clock is running down, so I want to pour a little more in here. It's reported by the Obama campaign that they profiled voters with open source data and used that data to target voters for turnout and voter suppression. The IRS has used their search engine to target the president's political enemies. Now, if we can go this far, if all of these things are happening, if the answer is relatively yes to this list that I've given, then I would charge that it would be likely impossible to drive from Bangor, Maine to Los Angeles without leaving a data trail in this country. And all of these things can be justified by the Constitution, by statute, by case law. Am I close, and how would you respond to that big question?
Yes, sir. If the predicate to each of those 8 questions is in the U.S., and if the further predicate is can the NSA, the answer would be no to all of those questions. Is it technically feasible to do some of those things? Of course. And some of those things are, in fact, done by marketing organizations, by the telecommunications providers who attempt to determine the flow and the allocation of resource bandwidth to their resources. But the National Security Agency, as a foreign intelligence entity, lacks the authority and, frankly, lacks the collection to do the things that are on that list of 8 questions.
I'd look to drill into that a little deeper if I had the time, but thank you, and I'll yield back.
Sir, we'd be happy to take a visit at NSA or come down and talk to you in whatever detail you'd prefer.
Chair, thanks, gentlemen. Recognize the gentleman from Tennessee, Mr. Cohen, for 5 minutes.
Thank you, Mr. Chair. First, I'd like to make a point. One of the previous questioners took the opportunity to attack the administration and said this administration has used the ends to justify the means in many areas. I believe, Mr. Cole, you said that all these programs started under the Bush administration and have not differed from Republican and Democrat. Is that correct?
That's correct, sir.
I appreciate your clearing it up. And then to its question, the President and this administration on the IRS, I believe it's come out that they not only looked at Tea Party, but they looked at liberal groups and any group that they felt was more than 50% political to look at in IRS, and it's wrong to question this President on those issues once the facts have come out to show that it was not a partisan or issue-driven area. And I take umbrage on behalf of the administration at such questions and such allegations. Now let me ask you this, sir. Mr. Snowden, what security status did he have? He could see anything there that he wanted to? Was he limited in what he had access to?
Let me put that over to Mr. English.
Sure.
Mr. Snowden had a top-secret, special compartmented intelligence clearance. That's a standard for someone in the U.S. intelligence community given access to top-secret information. He, as a system administrator, had additional privileges that he could then set the permissions on various devices within the information systems, who could access things and how you could move data around.
Generally, how many people generally are in the same level as he was to access this information?
Across the population, again, in this forum, I'll be general in my description, but across the population, numbering in tens of thousands, then you would expect hundreds of people would have those sorts of extraordinary permission system administrative permissions.
So tens of thousands of people could have done what Snowden did?
No, sir. I would say that perhaps hundreds. And could I make a further distinction between his privileges in terms of what he could control? Like any organization, NSA has a side of its information architecture that is intended to make information available to people so that they might discover capabilities, they might find each other, they might pass email to each other. It's intended to be a free exchange of information. But then there's a production side that is much more rigorously controlled, and there's a need-to-know rule philosophy on that side. Mr. Snowden took ruthless advantage of the former and did not have access to the latter except in some limited circumstances in the training he undertook in the last few months of his.
I asked in a letter, and you responded to me, I believe I got it last night, about the background on the security processing of Mr. Snowden. I was concerned that a high school dropout, not that there can't be great high school dropouts, but it shows you can't meet certain criteria, because basically finishing high school is you're going to jump through the loops. A guy who wouldn't jump through the loops, and he's shown at other places he wouldn't jump through the hoops, and he wouldn't do that, to put him in that type of top security level, I think is questionable. But it was said that the Associate Directorate for Security and Counterintelligence begins the clearance process. Is any of the work of the Associate Directorate for Security and Counterintelligence contracted out, or is that all done by government employees?
I think the determinations of whether to grant a clearance or not, it's an inherently governmental function, and so that would be retained by government employees. But in the investigation, the determination of the facts and circumstances associated with anyone's clearance determination, some of that would be contracted out. I could provide the details.
Does it concern you at all? Should it be contracted out, or should that be strictly in-house?
There's an inherently governmental decision to be made in that, and that therefore should be withheld and retained inside the government. The production of information in terms of conducting interviews, investigations, I think that some of that can be reasonably contracted out such that the synthesis and an examination of that is done by someone that has the higher trust.
And how did Mr. Snowden take this data with him? He's got certain information in Moscow with him now. How did he do that?
Sir, I don't actually know precisely how he took the information with him, and it's a matter of investigation. I think in due course we will know, and we'd be happy to provide.
But he would have probably taken it on some type of a disk or some type of a little with him from a secure facility, I presume.
I'd just be speculating. I think that that's possible.
Well, should there not be some changes in the procedures to make sure that people don't leave that secure facility with disks or anything else?
Sir, I would say that we're examining all of that. There are some controls already in the system about who can download to secondary storage devices.
All right, let me ask Mr. Cole. You mentioned that the judges come from different administrations, the FISA judges. Would it surprise you to know that 10 of the 11 judges all were appointed by Republican presidents?
These are, it wouldn't surprise me. It wouldn't surprise me either way. These are selections that are made by the Chief Justice.
By the Chief Justice, who's a Republican appointee. And he's picked 10 of the 11 judges he's picked were appointed by Republican presidents. Yet if you go back over history, back to Jimmy Carter, it's about the same number of years. There's a difference of 4 of Democratic and Republican presidents. But he chose Republicans. Do you think there should be some change to make sure that there's possibly an ideological balance on that FISA court?
You can answer the question. The gentleman's time has expired, but you can answer the question.
I think those are issues that we can discuss. That we try to take partisan politics out of the judicial aspect of it, and it operates, I think, best when it is insulated from that.
I thank the panel, and I thank the gentleman from the Palmetto State.
Thank the gentleman from the volunteer state. The chair would now recognize the gentleman from Texas, Judge Poe.
Thank the chair. Thank you for being here. My background is, as the chairman just mentioned, a judge. I spent 22 years at the criminal courthouse in Houston trying everything from stealing to killing. So I don't like criminals at all. But I have looked at the Constitution and read it. And I'm going to just read you one phrase that all of you know probably by memory. It's the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue except upon probable cause, supported by oath or affirmation, and particularly describing the place to be seized and persons or things to be seized. And as we all know, generally speaking, historically, warrants are brought to judges by law enforcement, and the judge signs or doesn't sign the warrant, issuing the paper to go out and seize that person in that specific place. Now, I have read that numerous times, and I don't see in here anywhere as an exception for national security. Do any of you see a national security exemption to the Fourth Amendment?
There's not a national security exemption, but several courts have held that there is that the warrant requirement of the Fourth Amendment does not extend to the conduct of foreign intelligence. It's not to say that the reasonableness requirement doesn't apply.
Okay.
The warrant
I just have a little bit of time. I understand your answer. We're not talking now about foreign intelligence. Let's set the foreign issue and terrorists overseas where they're running wild, set that aside. Let's talk about searches and seizures in the United States of American citizens. Question, is there a national security exception to the Fourth Amendment when it comes to American citizens in the United States? Do you see that in the Fourth Amendment, any of you?
Again, there is not a national security exception. There's a case of the Supreme Court called United States versus United States District Court. It is possible to have foreign intelligence collection against Americans, and I offer you the situation of an American who's a spy for Russia. We can be collecting valid foreign intelligence there, even though that person is an American. It happens that the Congress in the FISA has established warrant requirements for electronic surveillance and so on.
I understand that, but the Fourth Amendment doesn't give that exemption.
With due respect, there are cases that say there is an exception.
We're going to argue till the sun goes down. The Fourth Amendment doesn't mention national security exception when it comes to the Fourth Amendment. That has been expanded throughout the years because of FISA, because of court rulings, but it's not in the Fourth Amendment. And I think that we should remember that the Fourth Amendment was written because of what was going on with King George III, how he was going into people's homes in the United States, the colonies in those days, and seizing things with his redcoats without a warrant. That's the basis of it. And I hope we don't get to a point in this country, in the name of national security, that we infringe and bruise the Fourth Amendment. I don't know about any four of you.
Would the gentleman yield?
I won't. Sorry. I don't know about the four of you, but I have been in the former Soviet Union when it was, we can't use this word anymore, communistic. And I was there. And the actions of the citizens were constantly under surveillance by government. And anything that was done, the government would say, we're doing this for national security reasons because of those bad old Americans overseas. We go into your homes, we bruise the concept of rights, all in the name of national security. That concerns me. And I hope as we move forward as a Congress, we rein in the concept that it's okay to bruise the spirit of the Constitution in the name of national security. Question. People who have had the law, let's say, violated. I think the Snowden, I don't like him at all, but we would have never known what happened if he hadn't have told us. Do they have a recourse against the government for improperly seizure of their records? Is there a recourse?
You may answer the judge's question. This time has expired, but you may answer the judge's question.
It depends on the nature of that seizure, depending on where they came from. For example, if it comes from a third party, it's not necessarily their records, but the phone company can certainly challenge the subpoenas. And if it was to be used against them in a court, they would be in a position to be able to challenge that use.
I thank the chairman. I have other questions I'd like to submit for the record for the four panelists.
And I am confident that one of your colleagues will yield you time, Your Honor, since you've made it known that you want it, and if they won't, I'll give you mine. The chair will now recognize the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. Mr. Cole, to follow up on some of the principles that you were just talking about, are you familiar with the case of State versus Maryland back in 1979, U.S. Supreme Court?
Smith versus Maryland?
Yes.
Yes, I am.
Having to do with telephone records. Is that correct?
That's correct.
And the question was whether or not there was a Fourth Amendment privacy interest in telephone records held by the telephone company.
That's correct. That was the issue.
And how did the court rule on that issue?
The court ruled that there was no reasonable expectation of privacy in those records because they really belonged to the telephone company. They didn't belong to the individual who they related to.
Now, is that case applicable to the case or to the issue of collection of metadata?
Yes, sir, it is.
All right. And so it was the collection of metadata, domestic to domestic phone calls, metadata, not content, but metadata, domestic to domestic, domestic to foreign, foreign to domestic. Is that correct?
That's correct. That's the metadata that we're talking about here.
That is the program that Edward Snowden revealed. Is that correct?
That is correct.
And he also revealed a program called the PRISM program. Is that correct?
That is correct as well.
The PRISM program was a program that enabled the collection of Internet metadata, not content. Is that correct?
No, that's not correct.
That is not correct. Okay. Explain to me what the PRISM program...
PRISM, and I can defer to some of my colleagues if I get any of this wrong. PRISM was under the 702 provision, which allows collection of content, but it's only content of non-U.S. persons who are reasonably believed to be outside of the United States.
Okay. So that is the PRISM program, which collects data, including content, from foreign communications, and then there is a minimalization process of eliminating domestic to foreign or foreign to domestic communications that were not relevant to national security. Is that correct?
That's generally correct, or some serious impending death or something like that if there's an emergency, but generally that's correct.
Now, that program, certainly we don't want our adversaries to know of what we're doing to watch them and to surveil them, foreign intelligence collection. We certainly don't want that to be exposed to the public.
No, sir, we do not.
We need that to be kind of secret. But with respect to the data collection of domestic to domestic metadata, why is it necessary that the American people not know of that program? Why is it that that program has to be confidential, classified, secret?
I wasn't there at the time that it was classified, but I can give a little bit of speculation. The more people know about the way we go about trying to identify terrorist networks, the more they will avoid the kinds of ways that we use to do that. They may start to avoid communicating through phones.
Yeah, if they can't communicate through phones or can't communicate over the Internet, what will they do? Take a can on one end and put a string to it, and a can on the other end? Will they communicate like that?
It may be more difficult for them to communicate, but they may find other ways or other mechanisms or other providers to do it through.
Well, it's always going to be a cat and mouse game in that regard.
That's correct.
The American people, in my opinion, should know of the activities that affect them. The collection of telephone metadata is not personal information. However, the government collecting this information and creating a database with which it can then use to investigate information that is acquired from foreign sources related to national security, a terrorist act, the American people may conclude that they want their government to collect that data. But if they don't know that the government is collecting the data, then they find out after it's leaked by someone who thinks that it's illegal, they find out in that way, and then they start to lose confidence in their government. Is that the situation that we find ourselves in today? Anyone?
The gentleman's time has expired. You may answer the question.
And by the way, I'm a former judge too.
Your Honor, had I known that, I would have addressed you appropriately. Please accept my apologies, Your Honor.
Thank you, Mr. Chairman.
I think that's always the kind of issue that we wrestle with, which is the issue of trying to balance the need to protect the secrecy of some of these programs so that they will be effective, with the need to be as transparent as we can about it, because that's the kind of society we live in where people participate in the decisions of government. So those are always difficult balances to find, and that's the one we're trying to find and we find ourselves in right now.
Thank you.
Thank you, Judge Johnson. The chair will now recognize the gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman. I think more important than balancing those needs is to balance our liberties with our security, and I think that's what we're all concerned about today. We're looking at a system that is allowing the government to collect everybody's metadata. And just recently I had the opportunity to travel through a series of countries, and I won't mention which country it is, but I was told before I went to that country that it was a police state. And I had heard that term my entire life. I had never really understood what it meant. I had heard about the USSR and other nations that were constantly surveilling their citizens and the people who visited that country. And I had never experienced what I experienced when I was there, where I actually felt literally like I was being observed in every place that I went. And the place was very secure. The place was very safe. There was very little crime. There were few things happening, but it was because people had given up their liberty in exchange for security. And I think that's what this committee and I think what most Americans are concerned about, that we're going to give up our liberties in exchange for security. So I just have a few questions. Mr. Litt, you said in your introductory statement that this was not a rubber stamp, that the judges were not a rubber stamp, but I had a hard time following your argument, because your argument seems to be that because the judges are actually reading the material, it is not a rubber stamp. That seems to be a nonsensical argument to me. I can either rubber stamp something by reading the material or not reading the material. That doesn't seem to be a determination of whether somebody's rubber stamping something. It seems to me that the difference, I was a criminal defense attorney, never a judge, just a criminal defense attorney.
There's still time, sir.
No, thank you. And it seems to me that there's always a check and balance on the power of the government. Even when you go get a warrant, when something happens, you still have an adversary on the other side who can contest it in court, who can contest it in hearings, who can contest all those things. But that's not happening in the FISA court. How can we address that?
So I have a couple of things to say, if I would. On your first point about the FISC being a rubber stamp, it's not just that they read the opinions. I mean, the idea of a rubber stamp is that they don't think about it. They just say, you're giving me this, approved. And that's not, my point is that's not what happens. Mm-hmm. They not only read it, they ask questions, they think about it, they push back. They do a careful study and analysis. So it wasn't, I didn't mean to suggest that it's only because they read it.
Okay. Right.
On your second point, if I can just get philosophical for a second, this goes to one of the other points I made in my opening remarks, and that is that what we have here is the oversight of intelligence activities. It is not it's not a litigation. It's not a criminal trial. It's not a civil trial. This is a
and I understand that, but let me stop you there. And again, like Judge Poe did just a minute ago, I'm not so worried about Section 702. I'm not so worried about foreign intelligence. I'm worried about you're gathering my information. It's my personal data that right now the United States has. And I'm concerned about that. I'm concerned about you having the data, the metadata of every single American. And I think there should be some mechanism for us to be able to counter whatever the, and I have all respect for judges. I served, as a lawyer for 15 years. They were usually right and I was usually wrong. At least I would tell them that. And I have a great respect for the legal system, for the judiciary system, but I am concerned when you don't have somebody on the other side advocating for the rights of citizens of the United States. And it's something we need to discuss here in this committee, and we need to figure out. Now, let's go to Smith versus Maryland. Mr. Cole, you mentioned Smith versus Maryland. It's totally not an analogous case, I believe, to what we're talking about here. What in the FISA statute or in the Patriot Act allows you to collect the data of every single American? That's what I'm not understanding, because even if you follow Smith versus Maryland, you're talking about one individual who was suspected of committing a crime, and now you're telling me, and we have just recently learned, that we are collecting the metadata of every single American, and that concerns me.
I think there's two different issues that are involved here. Smith versus Maryland only goes to the issue of whether the Fourth Amendment applies to this kind of data, not whether the Fourth Amendment prohibits or allows the kind of collection under 215. That's a separate issue, and that's governed by the provisions of the statute of Section 215, which requires that in order for a court to approve the collection method that's being put forth, it must have demonstrated to it that it is relevant to the investigation of these specified terrorist groups. The relevance is found in the combination of the two orders. It's the limitations first, where the court says you can't just roam through this anytime you want, for any purpose you want, any day you want, any time you want. That cannot be done. You must find reasonable articulable suspicion that the number you want to query is related to one of these terrorist groups.
And I understand. We've heard this argument before, and my time has expired, but I think that determination has to occur before you collect the data, not after you collect the data. And I think that's what's wrong with what you guys are doing at this time. But I appreciate your service. I appreciate you being here today.
I thank the gentleman from Idaho. The chair will now recognize the gentlelady from California, Ms. Chu.
Thank you, Mr. Chair. I was listening to the steps that you outlined for actually doing a query for the metadata, and you were describing it as a way of showing what kind of constraints you use on this information. So, Mr. Inglis, I'd like to ask this. It sounds to me like first you have determined that the phone numbers of all the American people is relevant. Then, in order to actually query the database, you have to establish reasonable, articulable suspicion. And in order to do that, you have said that 22 people at NSA can approve the query. I wonder, why is that these 22 people have this power? They appear to be acting like court judges, and why would they be performing the job that the FISA courts were set up to do? In other words, shouldn't the agency go to a FISA court to seek to retrieve data from a third party's database when they actually have need of specified information? And who are these 22 people?
So the court, in its order, has prescribed that particular procedure, has prescribed that those people, the number of people, would have that authority, and that those people would follow court-ordered procedure, and that they be trained to a standard, again, approved by the court. And so that's how we came to that particular implementation. Defer to Mr. Cole for any of the legal analysis under that.
The only issue that I would take some differing with how you describe it is by saying you first have to define or find that all of those records are relevant. This is a combination of two different court orders that come together, and they have to be read together as you look at this. So it's not just one or the other. It is a whole program that is put together and presented to the court with the limitations and the oversight and the restrictions on how it can be accessed. Only with all of those considered as a whole does the court then make the relevancy determination.
Well, then let me continue on with the description that you gave with regard to how you proceed along these lines, which is that after they approve it, then it appears that after the fact you have an audit, and then you file papers with the court on this audit, and then the Department of Justice reviews it.
It's not exactly in that order, and again, Mr. Inglis can correct me if I'm wrong. There is the documented reasonable articulable suspicion that takes place ahead of time. That is then reviewed again by supervisors ahead of time to make sure that it is being done properly and the standards are being applied properly. The query is then made on periodic basis. The Department of Justice and the Office of the Director of National Intelligence, the Inspector General for NSA, all sample and look at these things to make sure that, in fact, it's being applied properly and that it's being done properly and that there aren't any misapplications of it. And there are periodic reports that go to the court of any compliance problems. We have to talk about every 90 days getting renewed authority. And when there are any issues that come up and any problems that are discovered, they're reported to the Congress and to the Intelligence and the Judiciary Committees as well. So there's a lot of different checks and balances and audits that go on, both before the query is made as well as after the query is made. And if there's problems found with the query, then that's all fixed, and whatever is collected is remediated.
Well, my concern with regard to the second half is that it is retroactive, and it seems that more of the protection should be on the first half of these steps that you're talking about. And are those documents with regard to your DOJ reviews of the queries, are those available to this committee?
I would imagine that those would probably be classified documents. I'd have to go back and check, but that's it certainly would look at the facts that we have and how we get them and what the nature of them is. So my guess would be that those would be classified.
Are they, well, you said they're reviewed by Congress, but where?
I think that the review takes place. There are reports that are made when leadership of the committee or other aspects of the committee want briefings in classified settings. Those are arranged as well.
Okay. Well, let me ask also about the issue of court documents. I understand that secrecy is essential when conducting any intelligence investigations, but we have to ensure that these efforts are working within the legal framework of the Constitution. We learned earlier this week that a FISA court agreed to declassify documents from a 2008 case in which Yahoo raised concerns about NSA's data collecting program, and other requests have been filed by companies that are in similar situations. What is the harm in releasing this type of information? Shouldn't the American public be informed about how this type of information is collected and used, and why couldn't you redact the information that is of security concern?
You may answer the question. General Lady's time has expired, but you may answer her question.
I think we all agree that that's something that should be done. It's difficult to do because frequently the classified information is fully intertwined with the legal analysis, but we recognize that it's our obligation to make as much of this available to the public as we can, and we're working as hard as we can to accomplish that.
Thank you.
Thank the General Lady from California. The Chair will now recognize the gentleman from Texas, Mr. Farenthold.
Thank you, Mr. Chairman. I don't know where to start here. I've got so many questions. I guess I'll start with Mr. Cole. Do you see any limitation under the Fourth Amendment or the Patriot Act on the government's power to gather information en masse on people?
Yes, sir. I see very many limitations from both the Fourth Amendment and from the Patriot Act and from the FISA Act. There are many, many limitations that are put in and many, many checks and balances both through the United States.
All right, so let's go over a couple of those. I assume you'd have to go to the FISA court, and those are one of the checks and balances. Could you go to the FISA court and argue that you had a right to obtain, say, either an individual's or a group or every American's tax return? Could you argue that with a straight face?
Well, I think
I've got a long list of them, yes or no?
Any individual's tax return, there are separate laws that cover the acquisition of tax returns.
All right, so you could get tax returns. Could you get it somebody's permanent record from school?
If it was relevant to the investigation, you could go to the FISA court and ask.
Could you get somebody's hotel records?
If it was relevant.
Could you get the records of everybody who stayed in a particular hotel at any time?
If you can demonstrate to the court that it is relevant to the investigation.
Could you get you could get my Visa MasterCard records?
If I can demonstrate to the court.
All right. Could you demonstrate? Could you argue with a straight face? You could demonstrate to the court to create a database of everybody's Visa MasterCard, every financial transactions that happened in the country, because Visa and MasterCard only keep those for a couple years.
Mr. Farenthold, that's all dependent on exactly what I'm investigating and what the relevance of the information would be and how it would be used and how it would be limited. All of those have to go into it. It is not a simple yes or no, black or white issue. It's a very complicated
Could you get Google searches?
I'm sorry, sir?
Could you get all those searches I made on a search engine?
Again, it would depend. I'd have to make a showing to the court that that kind of information was relevant to the investigation.
Could you get all Google searches and then come back and say we're going to search them later when we've got that information?
It would depend on the way that I would be able to search them. And again, under 215 of this statute that we're talking about, it's only if I can show that it's related to specific terrorist organizations. It's
you
not
get the
for
GPS
anything
data
under
from
the
my
sun.
phones too, probably?
I'm sorry?
You could probably make a good argument for getting the GPS data out of my phones or the mapping software I use on my phones too.
Again, there's great limitations on how I can do that, and only if it is relevant to an investigation of those specific terrorist organizations.
All right, but how is having every phone call that I make to my wife, to my daughter, relevant to any terror investigation?
I don't know that every call you make to your wife...
But you've got them.
I don't know that they would be relevant, and we would probably not seek to query them because we wouldn't have the information that we would need to make that query.
But, you know, somebody like Mr. Snowden might be able to query them without your knowledge.
I don't believe that's true, but Mr. Inglis could answer that. I don't think he would have access to that or be able to do it.
Okay.
We don't believe that he could query those without our knowledge, and therefore those would be caught.
All right. That's slightly reassuring. The Fourth Amendment specifically was designed, as Judge Poe pointed out, to prohibit general warrants. How could collecting every piece of phone data be perceived as anything but a general warrant?
Because the phone data, according to the Supreme Court, is not something within which citizens have a reasonable expectation of privacy.
So do I have a reasonable expectation of privacy in any information that I share with any company, my Google searches, the email I send? Do I have a reasonable expectation of privacy in anything but maybe a letter I hand deliver to my wife in a skiff?
Those are all dependent on the facts and circumstances of the documents we're talking about. In the case of metadata, the Supreme Court specifically ruled that there was not coverage by the Fourth Amendment because of no reasonable expectation of privacy.
I just want to point out how concerned I am about this data being so easily available, and just with a stroke of a pen, Congress and the President could change the search criteria as to what's searched there, change the definition of a terrorist, or search the fact that this data exists in the hands of the government. We saw what the IRS has done with tax returns targeting people for political beliefs. Let me ask you one other quick question. Why do these orders not violate the First Amendment? We've talked a lot about the Fourth Amendment, but why doesn't it violate the First Amendment, my right to freedom of association and my freedom of speech, having the government know who I'm talking to and when?
Again, these are issues that are looked at by the court in determining whether any constitutional rights are involved. We don't know who it is that has a specific phone number that's being called.
And you can't look that up on one page on the internet. I yield back.
Gentleman's time has expired. The chair will now recognize the gentleman from Florida, Mr. Deutsch.
Thank you, Mr. Chairman. And Mr. Chairman, like many Americans, I was shocked by the revelations that the NSA has been secretly collecting phone records, internet data on millions of Americans, thanks to a lawfully issued warrant approved by the Foreign Intelligence Surveillance Court, often called the FISA Court. Many members of Congress, myself included, were left completely in the dark about the extent of the NSA's data mining program, and I worry about the balance between legitimate national security needs and the constitutionally protected rights of all Americans. The government is stockpiling sensitive personal data on a grand scale. Intelligence officers, contractors, and personnel only need a rubber stamp warrant from the FISA court to then learn virtually everything there is to know about an American citizen. The American people have a right to know about this program and, at the very least, know that such a program is operating within our system of checks and balances. I believe Congress has a constitutional obligation to protect individual privacy rights, and I believe it's time to re-examine the Patriot Act, insert greater accountability into the FISA court, and ensure that our laws cannot be interpreted behind the backs of the American public. With this hearing, this committee has begun this important work of oversight and repair, and I thank the chairman and the ranking member for calling this hearing. I thank the witnesses as well for participating. Mr. Cole, I want to ask you about the October 2011 letter sent by then Assistant Attorney General Ronald Weich to Senators Wyden and Udall regarding Section 215. The disturbing information that Senators Wyden and Udall learned, however, was classified and was thus kept from the American public and even most members of Congress. Now, Mr. Weich seemed to imply in his response to Senators Wyden and Udall that because Congress, or at least a select number of members of Congress anyway, received intelligence briefings in accordance with the Patriot Act, that there's no cause for alarm that the government was using some sort of secret law to expand its surveillance activities. Now, the Patriot Act was passed in response to the horrific attacks on 9/11, designed to bolster national security by expanding the investigative techniques used by the government and law enforcement officials to hunt down suspected terrorists, something that we all agree is important. But Section 215 had a standard of relevance, and there had to be concrete information linking a person to a terrorist organization before the NSA could secure that person's information. Instead, what we've learned is that the FISA court has essentially rewritten Section 215 to say that any and all persons' records may be considered relevant, therefore allowing the NSA to indiscriminately collect sensitive data on all Americans. The fact is, in 2012, the government made 1,789 requests to conduct electronic surveillance. Court approved 1,788. The government withdrew the other. Now, as a member of Congress who was not privy to those intelligence briefings, I had to accept Mr. Weitsch's assurance that there's no secret law. But in the aftermath of these recent leaks, however, it seems that there may be secret laws, laws not passed by Congress, laws not publicly interpreted by the Supreme Court, but rather secret laws born out of a classified interpretation of the Patriot Act by the FISA court. The New York Times recently reported that the FISA court has quietly become almost a parallel Supreme Court, serving as the ultimate arbiter on surveillance issues, I would point out, with only the arguments of the federal government alone to be considered. Now, even a former FISA judge has come forward with concerns that the body has become a de facto administrative agency, which makes and approves rules for others to follow. Now that it's become public that FISA courts have broadly, perhaps even unconstitutionally, redefined the relevance standard in Section 215, is it still the Department's position that the government isn't essentially operating with a secret playbook?
Mr. Deutsch, I don't think we are operating with a secret playbook. There is, again, as we've discussed in many instances in our hearing today, the tension that exists between maintaining the integrity and the secrecy of some of the national security investigative tools that we use and making sure that people know about it. We have, in the course of the reauthorization of the Patriot Act, on several occasions, done classified briefings, made individual.
Mr. Cole, I'm sorry to cut you off, but I only have a second left. Let me just broaden the question then for a second, because I'm speaking about these decisions that the FISA courts make as the supreme arbiter of this law. And stepping back for a moment at a more basic level, does the panel understand why the American people may find this revelation shocking, that secret court rulings could expand the powers of the federal government beyond perhaps what was originally authorized by law, and that an entire chapter in our laws is being written outside of the three branches of government altogether?
I think, again, this is an area where we are looking to see what kinds of opinions from the FISA court we can make public. These are things that we are trying to do and trying to go through. All significant opinions and all significant pleadings that have been filed with the FISA court are made available to the committees, to the Intelligence Committee and the Judiciary Committee, so they can see them. We're not trying to keep them secret. We're just trying to maintain the classified nature of some of these. But these are issues that we're trying to grapple with and trying to determine what we can let out so that we can have this broader discussion.
I thank the gentleman from Florida. The chair would now recognize the gentleman from North Carolina, the former United States Attorney, Mr. Holding.
Thank you, Mr. Chairman. In a different professional capacity, I successfully used FISA warrants to investigate, disrupt, and prosecute terrorists and terrorist acts, and I can attest that not only are they effective, but there are very high burdens and hurdles to use FISA warrants, and they are significant. But I want to step for the few moments that I have outside of the prosecution of terrorism and the investigation of terrorism and just talk about the use of telephone records in everyday garden variety criminal cases, whether they are public corruption cases, fraud cases, drug cases, and Mr. Cole, I'll direct my questions to you. If you could step through for us how the Department of Justice, prosecutors, and investigative agencies obtain telephone records, just in garden variety cases, and how they're ultimately used.
There's two different ways we do it pursuant to the law. Historical telephone records that exist for prior calls we can get with grand jury subpoenas in a normal criminal case. Those can be issued by a prosecutor, delivered to the telephone provider, and ask for a range of data.
So no judicial involvement, just a grand jury involvement.
There's no judicial involvement, just the grand jury involvement, and the prosecutor defines the scope and the nature and the numbers that are involved.
So the prosecutor could request telephone records going back as long as they want to. The only limitation being, does the telephone company still have those records?
There would be one additional limitation. The telephone company could challenge the subpoena as being overly burdensome and irrelevant to any reasonable investigation, and the court could take that up, which would be in a sealed proceeding because it's a grand jury proceeding, so it wouldn't be public.
And what would the standard that the judge be using to evaluate the motion to quash?
Generally relevance to the investigation.
So the Fourth Amendment doesn't come into play there.
Not for telephone records, it does not.
And this is available to prosecutors, federal prosecutors across the country.
Yes, it is.
And the only showing that they have to make to the grand jury is what? That it's relevant.
That it's relevant.
And once you have gotten the telephone records, and it shows, let's say, hits between the person, the subject that you're investigating, and a relevant other person in the investigation, then what do you do to start listening to those telephone calls?
Well, if we wanted to listen to any telephone calls, and that would obviously be just telephone calls that would start happening into the future, we would have to go to the court and seek authorization under Title III of the U.S. Code to get a wiretap. And we would have to show probable cause to believe that, in fact, the person talking on the phone was involved in criminal activity, and that through that phone they were discussing criminal activity, and we would obtain evidence of that criminal activity by listening to the calls.
Would you hazard to make a guess of how many wiretaps are in use on a daily basis?
I couldn't hazard a guess, but there are a fair number of them.
Probably hundreds, perhaps?
Probably.
As far as my friend Mr. Scott was talking about, if you find evidence of some other criminal conduct during an investigation, let's say during a Title III wiretap, you're investigating one crime, you hear a conversation that suggests that another crime is being committed, are there any limitations on use?
Generally not, other than the restrictions on how you can use wiretap information, and there's restrictions on that and the secrecy that's involved in those and the protection of innocent calls. But generally you can use that information if it relates to other criminal conduct according to the rules of procedure in the law.
So my takeaway, having heard you describe in detail how the 215 program works and the 702 program works, the restrictions and limitations on use from those two programs is much more restrictive and limited than what prosecutors and law enforcement are using on a daily basis throughout the United States investigating garden variety crimes being committed by U.S. citizens.
In the main, there are some differences here and there. For example, the burden to get a wiretap may be a higher burden than for 702 coverage, but it's certainly, but it's a different burden if we wanted to do a FISA for somebody in the United States. That would be, again, a probable cause standard, but probable cause that they're involved in foreign intelligence.
Thank you, Mr. Chairman. I yield back.
Thank the gentleman of North Carolina. The chair will now recognize the General Lady from Washington, Ms. Del Benet.
Thank you, Mr. Chair, and thank all of you for being here today. Last month, when Director Mueller appeared before this committee, I stated that I agree with those who believe that greater transparency about the requests that governmental entities are making to Internet companies and providers will help inform the discussion that we're having on balancing national security with privacy rights and civil liberties. One of the questions that I asked the Director was how the FBI and the Department of Justice will respond to the request by Google that it be permitted to provide reports of the number of FISA national security requests it receives, as well as their scope. And at the time, Director Mueller noted that this was being looked at, and so I was wondering, Mr. Cole, if you're able to share with us what the response is to this request.
Unfortunately, this is a matter that is currently before the courts in litigation, so I can't say too much about it other than to reiterate what Director Mueller said, which is this is a matter that we are in fact looking at and take seriously.
Now, we do have some data that is out there already, because in March of this year, Google worked with, I believe, Google worked with the DOJ and the FBI to disclose in broad strokes the number of national security letters that Google receives, correct?
That's correct.
And so we do have some information. Do we know whether that information that was released has had any impact on national security?
Generally, it's hard to tell unless you have a substantial period of time afterwards as to whether or not it has an impact. So we haven't had enough time yet.
Okay, thank you. The public also now knows that the telephone metadata collection is under Section 215, the business records provision of FISA, and that allows for the collection of tangible things. But we've also seen reports of a now defunct program collecting email metadata. With regard to the email metadata program that is no longer being operated, can you confirm that the authority used to collect that data was also Section 215?
It was not. It was the Pen Register Trap and Trace Authority under FISA, which is slightly different, but it amounts to the same kind of thing. It does not involve any content. Mm-hmm. It is, again, only to and from. It doesn't involve, I believe, information about identity. It's just email addresses. So it's very similar, but not under the same provision.
And could you have used Section 215 to collect that information?
Hard to tell. I'd have to take a look at that.
Because I think it's important for us to know whether or not there's any limitations on the types of information within Section 215 that prevent you from collecting, whether it's email metadata or GPS and geolocation information, et cetera. How broad is that authority?
Again, it's only as broad as what the courts can find under 215 that is relevant, but there's different authorities in FISA, so we'd have to look to see how those all work together.
Mr. Litt, were you going to?
No, I was just going to say that it's important to remember that the 215 authority allows you to acquire existing records and documents, and it's limited to that.
Although you could argue that geolocation information may also be existing, and would you consider that to be metadata as well?
I think that the director of the National Security Agency has stated that we're not collecting that under Section 215, and that we'd come to the Congress and consult with the Congress before any decision was made to do so.
But you understand it's important for us to know what the breadth and limitations are as we look at policy, and clearly there's some confusion here right now, so we need to understand how it's being used and what information might be collected so we can make sure intent's delivered appropriately. So I agree with the President's view that we need to set up a national conversation on balancing privacy and security, but in order to have that conversation, have a productive conversation, we need information that's going to help fuel that conversation, information like the breadth of Section 215, et cetera. And so I hope we can continue that and get access to more information so that we can have a productive discussion going forward. And thank you for your time. I yield back.
Thank the gentlelady from Washington. The chair would now recognize the gentleman from Texas, Judge Gomer.
Thank you, Mr. Chairman. In answer to some of the other questions, you provided an adequate defense. The trouble is, we have seen the abuses of government. We have seen the gathering of data. And I can tell you from having been here, not when the Patriot Act was passed originally, but when it was extended back in my first term in Congress, it got down to where there were only 2 Republicans demanding any type of safeguard, I thought, and there were 2 of us that wanted sunsets. I was the one that argued for 25 minutes in our 30-minute pre-hearing meeting demanding sunsets, and then my friend Dan Lunger had the amendments, and we got at least 2 sunsets on 206 and 215. And the argument I made for 25 minutes that turned my colleagues, Republicans, around in our meeting was, I've seen how there can be violations of due process if everyone is not very diligent, and we need the safeguards in order to have proper oversight. And what we've seen and what's been disclosed of the monitoring scares me. We've had hearings in this room. People like Jerry Nadler have argued about dangers of government having too much information. And from my experience as a judge and Chief Justice with state judges and federal judges, and having practiced before a very conservative federal judge named Bill Steger and a very liberal judge named William Wayne Justice, I couldn't imagine anybody granting the kind of orders we've now seen granted. Just a blanket summary, go get all of these phone records. And I understand the assurances, no, we don't have names with them, but isn't it true that you can go on public or private data, any individual, and secure the names for different numbers? Isn't that true?
There are ways to secure the names for any number of numbers, maybe not every single one.
Right, and I recall back in 2002, as a Chief Justice at a conference, getting into a debate with a CIA lawyer who was arguing, look, banks have all your financial records, why shouldn't the government? And I was pointing out, as he said, conservative. It's because banks can't show up at your house, put you in handcuffs, throw you to the ground, and drag you off to jail, which has been done by the government. So there is an important distinction. And then we find out that though many of us opposed it, the Consumer Financial Protection Bureau has been gathering information on everybody's financial records, but they say the same thing that most of you are saying. Look, we're not putting the names with it. But isn't it true that that even the NSA can get access to the information gathered by the Consumer Financial Protection Bureau?
It's hard to imagine that could be true, but I would say that we can't pull the telephone numbers from this database under any circumstances other than that prescribed by the court.
But you're entitled to go. I mean, we've had this debate in here. You're entitled to go on the internet or go to private sources that any private citizen could and gather that information without violating any constitutional rights. Isn't that correct?
Certainly, but if the premise is we would do that to match names, identification, personal information against the telephone numbers, we don't have access to the telephone numbers unless we follow the prescribed rules of the court pursuant to a terrorism investigation.
But if you can gather the information that a private individual could and couple that with information that only the federal government, we're now learning, is gathering, then it really constitutes a grave threat to privacy. By the way, the Consumer Financial Protection Bureau said this, their director said this in testimony before Congress. The Bureau has also issued regulations that limit the circumstances in which it may disseminate internally, share with other agencies, or disclose the public confidential information. Share with other agencies. So they know they can share with other agencies if another agency or they feel it's helpful. This begins to be a little scary, and the justification we get seems to be, well, but look, there are a handful of cases where we have avoided terrorism by really gathering all this private information, and it makes me think, how many times could King George III have argued that? Look, by putting officers in every one of your homes that we were uncomfortable with, we ended up being able to avoid a couple of problems of violence. We don't want people in our homes, and that includes the federal government watching through a big eye through our computers. And I appreciate your being here today. Thank you.
Thank the gentleman from Texas. The chair will now recognize the gentleman from New York, Mr. Jeffries.
Thank you, Mr. Chair. Mr. Cole, am I correct that it's your position and position of everyone on the panel that the telephone records of potentially hundreds of millions of Americans in the form of metadata, as has been discussed today, is relevant to a national security investigation?
They are relevant when they are only queried under the limitations that are described by the court, where you have to have reasonable, articulable suspicion that it's connected to some terrorist matter and investigation.
So fundamentally, it's your position that they're relevant because the court, the FISA court, has articulated a set of criteria by which further inquiry can be undertaken. Is that correct?
They are, and they're relevant because you have to have it's the old adage of if you're looking for the needle in the haystack, you have to have the entire haystack to look through, but we're not allowed to look through that haystack willy-nilly.
Right. Now, in terms of looking through that haystack of these phone records that are acquired, based on reasonable, articulable suspicion, am I correct that it's 22 NSA individuals who are authorized to make the determination of reasonable, articulable suspicion? Is that right?
I'll give that to Mr. Inglis to give you the numbers.
That is correct, sir. Okay. So these individuals don't have to go back to the court in order to determine whether they can move forward with a more invasive inspection of the phone records of the Americans contained in the database that you've acquired. Is that correct?
They use the rules of the court to make the limited query that the court...
Right. They're using the rules of the court, but they're making the determination, not the court, as to the invasiveness of the further inspection. Am I correct?
On a case-by-case basis, they determine the selector.
Okay. Now, Mr. Litt, you've indicated that, in your view, the FISA court is not a rubber stamp. Correct? That was your testimony?
That's correct.
And I think in response to the distinguished gentleman from Idaho, you said, well, it's not a rubber stamp because they read, they ask questions, they push back, there's careful study and analysis. Is that an accurate characterization of your testimony?
It's reasonably accurate, yes, sir.
Okay. Now, we just had a baseball all-star game yesterday, and of course we know, nothing is as American as baseball and apple pie. And if you think back on the history of baseball, I just took a quick look. I'm a baseball fan myself. Now, Stan the Man Musial, great hitter from St. Louis, his batting average lifetime, he was close to being in the top 25, 331, Stan the Man Musial. Babe Ruth, 10th all-time. His lifetime batting average was 342. Ted Williams, the great lefty from the Boston Red Sox, his lifetime batting average was 344. Ty Cobb, the Georgia Peach. I may disagree with some of his views on social justice issues, but he was a great hitter. The #1 hitter all time.
363?
Based on average. 366. Pretty impressive, though. But I'm still going to continue to ask you questions about this dynamic. Now, I took a look. So these were the greatest hitters of all time. I took a look at what your batting average is as it relates to the FISA court. And I'm a little troubled at what we were able to determine. So am I correct that in terms of the total applications submitted since 1979, there were 33,949 applications submitted? Is that accurate?
I don't know the number. I wouldn't disagree with your number. I just don't know it off the top of my head.
And of that total number of applications, 490, it appears, were modified. Is that correct? You have no reason to disagree with that number. Is that right?
I don't know the answer.
Okay.
But if I can just add one.
Well, let me just make an observation.
Okay.
I've got limited time here. 1.4% of the total number of applications made were modified. But what's even more troubling, since 1979, 11 applications were denied. Is that correct? 11.
Again, I'll take your word for that.
Okay, so your success rate, your batting average, was 99% of the time that you've applied to acquire information that could possibly include communication from one American to another American. Yet, you've taken the position that the FISA court is an independent check to protect the civil liberties and constitutional rights of Americans. Is that correct?
So I guess the answer is that we're not exactly talking about baseball here. We have a situation. If you imagine a situation where the kind of interaction we have with the FISA court is the FISA court throws a pitch and we don't hit it, and we say the court says we want the pitch a little bit higher. Can you throw the pitch a little bit higher? And it's still not right to make it a little more inside. That's the interaction we have with the FISA court. They come back to us and tell us what we need to do to submit an application that will get approved.
Right. Those modifications, and I know my time has run out, only took place 1.4% of the times, and that's why I think we're all concerned, or many of us are concerned, that there's not an appropriate check on behalf of the Americans whose records could be subjected to an invasive search. I thank you all for your service. Yield back the balance of my time.
May I say one thing briefly,
Sure.
Mr. Chairman? The number for modification there, I think, does not reflect the full number of times in which the court asks questions and comes back to us. My understanding is that comes at the very end of the process, but there's a substantial give and take before we get to that point. So that's not a full reflection.
Chair thanks the gentleman from New York and now recognizes the gentleman from Utah, Mr. Chaffetz.
I thank the chairman, and I thank the four of you for your service. I know how much you care for your country, and we do as well, and I appreciate the dialogue. It's what differentiates the United States of America from most others. So, Mr. Cole, is geolocation information metadata, or is it content?
That is an area of the law that's, I think, evolving in light of the Jones case, and it's one that I think the courts are now grappling with. It's not clearly as
the courts did rule in the Jones case 9-0. They were pretty clear. Justice Alito was also fairly clear that Congress needed to grapple with this as well. Has the Department of Justice issued any guidance on Jones?
We're in the process of looking through that. Jones was based mostly on a trespass.
I know what it was. Have you issued any guidance on Jones?
We're in the process of looking through that to do it.
That is not an accurate answer. My understanding is there are at least 2 documents that the Department of Justice has issued to the Federal Bureau of Investigations, for instance. It was uncovered through a FOIA request. Almost every page of this was redacted. So you have indeed actually issued guidance on Jones, correct?
I'll stand to be corrected. If you have those, yes.
Will the Department of Justice provide to this body, to this committee, the guidance on Jones?
That's something we'll have to look into. There's lots of law enforcement.
No, wait a second. I know there are law enforcement issues. I know there are other things. Why would you not provide to the United States Congress, the Committee on the Judiciary, why would you not provide a copy of that guidance for this committee?
If it discloses law enforcement sensitive information and techniques of how we go about fighting crime and finding criminals, then we may not feel free to disclose it.
And to the chairman of this committee, I think this is one of the great concerns. So let me ask you again, is geolocation metadata or is it content?
It's not content, as that would be called. It doesn't give you the content of anybody's calls. All it gives you is information about where they are.
So you're saying, in other words, that geolocation you would classify as metadata?
I'm not sure that it's one or the other. I think there are times where there's things that are in between, and this may be one of those. It's certainly not content. It probably tends more towards metadata, but again, this is an evolving area of the law.
How is it evolving? I mean, we haven't... This is what scares me about what you're doing and how you're doing it. If you knew exactly where I was standing, you telling me that that's not content?
That's not the content of your conversation, no. And other people may see you. If you're standing out in public, any number of other people may see you there.
So, but if I was standing on private property...
This is part of what Jones talks about, is the trespass issue.
And they ruled 9-0 that it was an overstep and an overreach. So, are you collecting that data?
We are not collecting that data.
Let me ask the
Not under
NSA.
215.
Is the NSA collecting this data?
We are not collecting that data under this program. We believe that the authority could be granted by the courts to collect that attribute. We have not done that, and as Mr. Cole and Litt indicated earlier, the director of NSA has given an affirmation to the Congress that before such time as we would reconsider that decision, we would come back to the Congress.
How, going back to you, Mr. Cole, what other bits of information fall in this gap between metadata and content? What is this third category that you're talking about? What's the right word for it?
I'm not sure it's just a third category, Mr. Chafis. I think there's metadata that was described by the court in Smith versus Maryland, which is the telephone records that we've been talking about today that were covered by the 215 program that we've been discussing today. There's content, which is the actual the conversations themselves that people have. And there are any number of things that may fall in between those, and it's not just a third category, it's probably a continuum.
What else would be in that continuum?
I'm sorry, sir?
What else would be in that continuum?
It's hard for me to just hypothesize about all the many different things that could be out there and where they would fall in that continuum.
There's a report out today about license plates and that information that's being collected by thousands of camera readers and stored about specific location. Does that fall within this category?
In which category?
License plate readers.
The whole issue comes down to the reasonable expectation of privacy, and this is what the court bases its rulings on.
Do you believe that I have a reasonable expectation of privacy about my specific whereabouts?
It depends on where you are and how many other people see you as.
Do I have a reasonable expectation of privacy on private property?
In general, I think the courts are saying that there is a trespass theory that gives you a reasonable expectation of privacy, depending on whose property it is, whether it's your own or somebody else's, how many other people are there. These are all the types of issues that would go into that.
My time has expired, but Mr. Chairman, this is something we have to much more thoroughly understand. There is guidance out there, and I think this committee should be able to see it. Yield back.
We are working our way in that direction, and there will be another hearing. You'll be able to ask even more questions in a classified manner about questions you couldn't get answered here. So we thank the gentleman, and the chair now recognizes the gentleman from South Carolina, Mr. Gowdy, and thanks him for presiding for a period of time as well.
Thank you, Mr. Chairman. I was listening to my colleagues and our witnesses discuss these issues, and for whatever reason, Mr. Chairman, my mind went to a guy by the name of Joseph Hartzler. I don't know whether he's still with the Department or the U.S. Attorney's Office or not. He was the lead prosecutor in a case called United States versus Timothy McVeigh. And I thought to a presentation that Mr. Hartzler gave many years ago and the role the business records played in his ability to successfully prosecute that horrific act of domestic terrorism. And, Mr. Chairman, I thought to myself, all right, we asked you, Mr. Hartzler, to prosecute the crime after it took place. What if we challenged you with the responsibility to prevent the next act of terrorism? What tools would you need to be able to prevent crime as opposed to prosecute it in its aftermath? And while this is at some level a debate between privacy and public safety, to me it's also a debate between the difference between prosecuting something after it happens and then preventing it from happening in the first place. You know, Mr. Hartzler used hotel records. He used business records where McVeigh went and purchased certain materials. That was a very tedious, difficult case to prosecute, and the role the business records played in it. So this is what I would like to ask. I don't want to ask specific questions about the sections. I want to go to where the people in my district are, who are not trained attorneys for the most part, trained law enforcement officials. Mr. Litt, you would agree that the Constitution kind of sets the minimum standard by which government must conduct itself.
Yes, sir.
It's the minimum standard.
Yes, sir, and Congress has the power to set higher standards.
Exactly. So in Roper versus Simmons, if the Supreme Court says you cannot put someone to death who was under the age of 18 at the time they committed the offense, that does not keep Congress from saying we're going to raise it to 21.
That's correct.
Right. So who does get to decide whether or not our fellow citizens have a reasonable expectation of privacy?
It depends upon the purpose for which you're deciding it. For purpose of interpreting the provisions of the Fourth Amendment as the Fourth Amendment, the Supreme Court is the ultimate arbiter. For purposes of determining what's the appropriate behavior, how do you want to regulate the actions of government, that's Congress's role.
Well, I want to stop you. You say the Supreme Court's the ultimate arbiter. Are they the exclusive arbiter? Can the people weigh in on what they think they have a reasonable expectation of privacy in?
Absolutely.
But the Supreme Court doesn't have the benefit of public input.
Generally speaking, the public manages to get its voice heard in case of...
What I would hope they wouldn't listen to it. I mean, their job is not to weigh and balance, you know, to Jason's point, if you're on private property but there's a helicopter above versus if you're on private property and there are 4 other people at the picnic with you. I mean, you have no expectation of privacy in your face. I don't think anyone would argue you have an expectation of privacy in your face. But that does not mean that our fellow citizens want government to collect facial imagery data.
No, I think that's exactly the right way to frame it, which is to say that the Fourth Amendment, as interpreted by the court, sets the minimum constitutional standard, but that the Congress, based on input from the people and whatever sources, can determine, no, this is how we want to regulate the behavior of our government.
And technology can impact that?
We need to adhere to.
Agreed? Technology can impact that?
I'm sorry?
Technology? Technology can impact someone's reasonable expectation of privacy?
Absolutely.
Culture?
Yes, all of those factors come into play.
I mean, there are already currently business records that an AUSA cannot access with a subpoena. Unless the world has changed, you can't get medical records with a subpoena.
Right. There are statutory restrictions on what you can get.
You can't get IRS tax returns with a subpoena.
That's right. You've got to go through a more elaborate process.
Both of those are business records, right?
That's correct.
So the notion that Miller stands for the proposition that all business records you have no expectation of privacy because there was a third party involved, we just came up with 2 examples where that's not the case.
Well, that was a case interpreting what the Fourth Amendment meant. The other examples you've given are cases where, as you said, Congress has gone beyond the minimum requirements.
But there was also a statute in play in Miller. There was a banking statute in play in Miller. You've read it more recently than I have. But
no,
my point, my time is up. My point is this. All of us are asked back home by people who are not as well trained in the law as y'all are. And there is this growing skepticism about the conduct of government. And to the extent that the people can weigh in on what they have an expectation of privacy in, you can expect to see that scale balance back towards privacy and away from public safety unless we do a better job of regaining their trust and explaining why these programs are necessary.
So I couldn't agree with you more. I think that's absolutely right. I think, as Deputy Director Inglis said before, in the intelligence community, we try very hard to keep in mind both the protection of the national security and the privacy and constitutional rights of Americans. We think we've struck that balance in the right place. But if the people in the Congress determine that we've struck that balance in the wrong place, that's a discussion that we need to have.
Thank you, Mr.
Chair, thanks, gentlemen. And on that note, we thank this panel for giving a lot of answers. I think there are some that could not be answered here today, and therefore you might anticipate that we will have a subsequent hearing in a classified setting and ask additional questions, so whether it's of you four or someone else, I don't know, but I want to thank each one of you for helping us to engage in a very thorough examination of the issues related to these 2 sections of the law, and excuse you now. Thank you again.
Thank you.